To receive instruction. So can I always extend?
Mr. E. Tibafom, Learned Government Council, who prays for an adjournment on the ground that he is yet to receive required instructions in this case. Also heard me. Who else is appearing? Petitioner?
Yes, same for the petition.
Toshi Temjen.
Yes,
Heard Mr. Toshi Temjen Ponginer.
Lordship, in the meantime, I may be allowed to file my reply to the affidavit in opposition filed by respondent by Lordship.
Who also seeks some time to file an affidavit in reply against the affidavit in opposition filed by respondent number 5. You are also appearing.
Yes, Lordship, I'm for respondent number 5 and I've already filed my affidavit in opposition.
What is your name?
K. Lili Su.
Also heard Ms. K. Lily. So the considering the submissions made by Learned Council for the parties, let this matter be listed up
3 weeks.
after 3 weeks.
Once of that. Right back to item number 22 for hearing.
Yes.
Because petition and the schemes, if this matter may be taken off after a week.
Any objection?
No.
Heard Mr. Mo Zamir, Learned Council for the petitioner who, on the ground of personal difficulty, who seeks an adjournment on the ground of personal difficulty. Mr. N. Angami, Learned Senior Government Council, does not opposes the prayer. Hence, same is allowed. Let this matter be listed after a week.
Obliged.
Yeah, please, your lordship. Lordship, having item number 23 on behalf of additional AG Dim Sum, let this matter come up after 2 weeks, lordship. Today he has some difficulties. 23.
Any objection? What is your name?
Actually,
Heard Mr. Ajungli submitting on behalf of Mr. Imti Insong, Learned Additional AG, and praying for an adjournment. Stop. Mr. Pakindri Chapo, Learned Counsel for the petitioner, does not opposes the prayer. Hence, the prayer is allowed. Let this matter be listed after 2 weeks.
lordship, similar prayer, item number 5 to 9. Prayer, the affidavit has been sent to obtain signature and for some ratification. So kindly, this matter will come up next week.
Lordship, I have no objection if they file it next week, but then Lordship, they have been
Okay.
making the same prayer for the last 4
Heard
to 5 occasions, Lordship.
you file this time.
Next week, lordship.
There is some clarification.
Heard Mr. Toshio Longkumar, Learned Counsel for the petitioner. Also heard Mr. Jungli
behalf of additional AG Dim Sum.
submitting on behalf of Mr. Imti Insong, Learned Additional AG, who seeks a week time for filing affidavit in opposition, as same has been sent for obtaining the signatures. The prayer is allowed. Let this matter be listed after a week.
Without fail. They have to sign, they have to file it.
Let us wait for
Thank you, sir, Lordship. Lordship, I'd like to mention item 13.
1-3.
Yes, Lordship. But for 3 weeks to file affidavit in opposition.
What's her name?
Here on behalf of my senior alumni Edgar, counsel for the petitioner.
Learned Counsel for the petitioner is present. What is her name?
And Longkumar.
Yes, Mr. M. Longkumar, Learned Government Advocate, seeks a week's time,
3 weeks.
3 weeks time for filing affidavit in opposition. The prayer is allowed, list accordingly.
Vaishnav.
Official Lordship, I beg to mention item 15. Herein for the respondent, and will be given a week's time to fill the account.
You are for
For the respondent.
Grovi, heard Miss Grovi Skuru, learned counsel for the respondent. You have informed the
Yes, Your Worship.
who seeks a week's time for filing affidavit in opposition. Learned counsel for the petitioner does not opposes the same. Hence, the prayer is allowed. List this matter after a week.
Worship, there's an interview.
The interim order shall continue till next day.
Item 16, main list. That I need to file the on behalf of the state. I will be allowed 2 weeks time.
You have informed the petitioner.
I am for the state.
You have informed the counsel for you are there. Heard Mr. Moazamir.
Why I'm check.
Sorry, Moam Chin, learned senior government advocate, who seeks 3 weeks' time to file affidavit in opposition. The counsel for the petitioner does not opposes the prayer, hence the prayer is allowed. List accordingly.
Published. That's all. Lordship, I'd like to mention item 2.
Two. Yes. To what is the prayer?
Last application, last time was given to the petitioner to file as a position, as a reply. So I think, and then the petitioner is appealed.
Thank you, Your Worship.
Item number 2, what you have to say?
Lordship, we just served a copy of affidavit reply to the prime respondent 7 to 73, as well as to the government Lordship. And affidavit will be filing in the course of the day itself, Lordship. So now it's under preparation, Lordship. It's already on the process of filing, and the copy is already served to the respondents.
What is your name?
Apply on banyak. Appearing on behalf of Sandiang, Lordship.
Heard Mr. Swins, write his name. Appearing on behalf of Mr. Senti Younger, learned counsel for the petitioner, who submits that the petitioner has prepared the affidavit in reply and has already furnished copy thereof to the respondent number 7 to 73 and other
And also to state respondents.
and
other
also-
respondents.
and also to the other respondents. He also submits that the petitioner would be filing the same in the court during the course of the day.
That your
Day itself, Lordship.
if that be so, your worship, with the consent of the parties, let the matter be listed for admission hearing on Thursday, your worship. There is public interest is involved, urgency is there. Thursday, your worship.
Lordship.
On request of learned counsel, you show the attendance of counsel for respondent, Mr. T.B. Jamir. Write the names of other counsels, respondents.
I am for respond number 7 to 73.
And Miss Amy. Ah.
1, 5, and 6. 1, 5, and 6.
On request of learned counsel for both the parties, let this matter be listed for admission hearing on 14th of
It relates to recruitment process, your lordship, and recruitment of health workers, your lordship. So, and the matter is pending because of the interim order, recommend process, everything we will be help since last March. So in the interest of all the parties, public interest also is involved, your worship, as the missionary presiding, your worship.
This matter may be listed as, this matter may be taken up as the first item on the fixed date.
Lordship, much.
Lordship, if the interim can continue to the.
The interim order shall continue till next day.
Much of that.
But this Lordship, I beg to mention item number 10. Here I have received the counterfile by the respondent 3, 4, and 5, so I may be allowed 3 weeks time to file a reply.
May I please, your lordship? I'm appearing for respondent number 3, 4, and 5. I have served a copy to all the parties, Lord.
Heard Mr. Supo Vati Waling, learned counsel for the petitioner. Who is appearing for the government? Heard Mr. Write his name. Appearing for learned government advocate, appearing for respondent number 1 and 2, as well as Miss Apila Sanktam,
Lordship, standing counsel for respondent number 3, 4, and 5.
learned standing counsel, appearing for respondent number 3, 4, and 5. Learned counsel for the petitioner seeks 3 weeks time to file reply to affidavit in opposition filed by the respondents 3, 4, and 5. The prayer is allowed, list accordingly.
Obliged, Lordship.
Very pleased to Lordship. May I mention item number 11, Lordship? Lordship, I've just received a copy of affidavit in opposition filed by respondent number 1 to 5. Therefore, kindly allow me a few times to file my reply, Lordship.
What's your name? James. Heard Mr. James Newmy, learned counsel for the petitioner. Also heard Miss A. Iame, learned government counsel. Learned counsel for the petitioner seeks 3 weeks time to file affidavit in reply against the affidavit in opposition filed by the respondent side. The prayer is allowed. Let this matter be listed after 3 weeks.
Please, your lordship, may I please to mention item number 1. Your
Yes.
lordship, here I have sought some clarification on the instruction that I have received. However, your lordship, I have yet to receive that clarification instruction. So let the matter be come up after 4 weeks again, your lordship.
Who is counsel for the petitioner?
One.
For respondent number 4. It has been very quite some times.
What is your submission? Heard Mr. Muazzami, learned counsel for the petitioner. Also heard Miss Livika, learned government counsel, appearing for the state respondent, as well as Mr. T. Kezi, appearing for respondent number 4. Learned government counsel has prayed for 3 weeks time for seeking necessary relevant instructions in this case.
Your lordship, the 3 weeks, let the matter come up after 3 weeks. Let the matter come up after 3 weeks.
This time is sought for seeking instructions.
I sought clarification on the instruction that I have received, your lordship.
Yes.
So if I get that instruction, then will be clarification, then your lordship.
You have not still obtained the instruction.
Please send the clarification, your lordship. Instruction I have received, your lordship.
Okay.
But on the instruction, I have sought from some clarification. So that clarification I have yet to receive.
Not that late. Learned government counsel has submitted that she has sought for certain clarification on the instructions received in this matter, and which is yet to, which she has not yet received. And she has not yet received. Stop. The prayer is allowed. Let this matter be listed after 3 weeks.
Maybe please to mention, Item number 18 also used. 18.
Yes.
Your Lordship, here I am for the respondent number 1 to 4. So Your Lordship, here I'm yet to receive instruction. So some time will be given to me. Your Lordship, I don't know whether the notice has been completed against the respondent number 5.
Who is for the petitioner? Huh? Still awaited. On respondent number 5. Heard Miss, what's her name? Right hand name, learned counsel appearing for the please sue learned counsel for the petitioner. Also heard Miss Livika, learned government counsel, who seeks 3 weeks time for getting instruction in this matter. The prayer is allowed. On perusal of the record, it also appears that the service report in respect of the notices sent to respondent number 5 has not yet been received.
Your Lordship, since it's a week, let the matter come up after 4 weeks.
Okay. The stop, await further. Let this matter be listed after 4 weeks.
It's your Lordship, a big mention for your item number 19 and 20.
Item number?
19 and 20. Let this matter be listed after 3 weeks.
What is your name? Oh, yes. Heard Miss Vikono Kiso, learned counsel for the petitioner who seeks an adjournment on the ground of, why are you seeking adjournment?
On the prayer of my senior counsel.
On the ground of personal difficulty of the conducting counsel for the petitioner. Also, Mr. N. E.T. Bafom, learned government counsel, who does not opposes the prayer. The prayer is therefore allowed. Let this case be listed after 3 weeks.
Much obliged.
Lordship, I'd like to mention item 17. Service of notice of only respondents 6 and 7 is still available. I pray that the matter be listed after 4 weeks. I have taken the consent of the.
You will take fresh steps, or should we await?
Let us await, my lord.
Heard Mr. Senti Yange, learned counsel for the petitioner. Also heard Mr. N. Angami, learned senior government advocate. It appears from record that service report in respect of notices issued to respondent number 6 and 7 have not yet been received. Stop, await further. List this matter after
4 weeks.
4 weeks.
Lordship, there is an injury.
The interim order shall continue till next day.
Lordship, I also have a prayer for adjournment in item 3 and 4, my lord. Lordship, I may be granted 4 weeks to file my affidavit in reply. A similar matter is pending before the division bench on the same question of law. In fact, 2 writ appeals are pending, 3 and 4.
Oh,
So even if I file.
okay. Heard Mr. Senti Younger, learned counsel for the petitioner. Also heard Ms. A. Aimi, learned government counsel. Learned counsel for the petitioner has prayed for 3 weeks time.
4 weeks, my lord.
4 weeks time for filing his affidavit in reply. Stop. The prayer is allowed. Let this matter be listed after 4 weeks.
Much obliged, my lord.
My blessed Lordship, Lordship, I beg to mention item number 14. Lordship, I will be filing my affidavit within the first day.
Well, what is the name? What is the name?
Pichano for the state.
Pichan. Heard Mr. Muazzamid, learned counsel for the petitioner. Also heard Ms. Pichano, learned government counsel, who submits that
I'll be filing my affidavit today, Lordship.
she will be filing affidavit in opposition during the course of the day. considering this, when can we fix?
Next week for admission hearing. In the meantime, if necessary, I'll file a reply.
Okay. Considering the submissions made by learned government council, let this matter be listed after a week. In the meanwhile, the petitioner may file his affidavit in reply, list accordingly.
Right.
Please, Your Lordship, I beg to mention hearing item number 21. My senior is indisposed. Can you use the matter for 1 week? Thank you, Lord.
Heard Ms. Menusino, learned counsel for the petitioner. Also heard Mr. N. Angami, learned government counsel, senior government advocate. Stop. Learned counsel for the petitioner has sought for an adjournment on the ground that the senior conducting counsel for the petitioner is indisposed. Considering the submissions made by learned counsel, the prayer for adjournment is allowed. List after a week.
Large.
Lordship, this is an injury.
The interim order shall continue till next day.
Obliged.
From the supplementary cost list, for motion, item number 26.
Chief,
Yes.
matter pertains to commercial appointment. Lordship is well aware in the state of Pakistan, the government of policy under OM 79/2015 for commissioner appointment. Lordship asked for the office memorandum. Such appointment, that is the commissioner appointment, should be given only to the spouse, son, and daughter of the deceased government employee. Now, the present petitioner is the son of the deceased government employee who died in harness
When?
on 12/10/2014.
12 years ago.
Yes, Lordship. Right after the death of my father, Lordship, I've submitted my application for appointment on commissioning ground, which is not considered till date. What happened, Lordship, in the year 2022? As per the information furnished through the RDI, Lordship, altogether 109 vacancy, that is grade 3 and 4 posts arose in the department. All the vacancies has been filled up by other means. And out of 109 vacancies, Lordship, only 2 appointments were given to the commissioner applicant, Lordship. Lordship, as per the OM of 2015, Lordship, commissioner appointment should be given to the deceased, to the family members of the deceased not existing 5% of the direct recruitment vacancies arises during a year.
But in your petition at page 5, you have mentioned 50%.
Lordship, not existing 50%.
Not existing? Not
50% of the direct.
50% for
Yes.
compassionate appointment.
But in order to clear Lordship doubts, Lordship may kindly come to OM. Page 24. Page
Yes,
24, Lordship.
yes.
This is OM dated 17/9/2015. Subject revised commissioner
Okay,
appointment
okay.
scheme for state government employees who died in harness. Lordship, paragraph 2. Appointment on commissioner ground shall be given only to one of the following members of the deceased employee's family. Number 1, spouse. Number 2, son, or C, daughter only.
50% of vacancy arising during a year.
Paragraph 4.
Okay.
Paragraph 4 of the OM, Lordship.
We issue notice.
Lordship,
Before she notice lordship, we kindly come to the facts for how the petitioner case has been deprived for the authorities. Because it's already less than 10 years after I submit my application.
No, what do you want at this stage?
Lordship, we kindly see during from 2015 to 2024. Altogether 121
No,
vacancy
we are issuing notice,
yes, Lordship. Now I have an interim prayer, Lordship.
interim prayer.
Presently, there are 10 posts available in the department.
10 posts.
Considering the conduct of respondents in appointing the grade 3 and 4 post lordship during those past 11 years. Lordship, this post will be filled up by the respondent authorities at any time, Lordship. Therefore, my prayer at this petition, Lordship, is to reserve at least 3 posts for the commission applicant. Otherwise, the respondent authority may fill up this then post by other means without giving to the commission applicant, Lordship. Lordship, we kindly come to page
Yes.
Lordship, page 46. This is the latest information received from the Department, Lordship. This is an earlier application submitted. And Lordship, the information short for number 1 is seniority list of the candidates for commissioner appointment with effect from 2014 till date. Number 2, details of the commission appointment made with effect from 2015 till 2025. Number of group C and D vacancies both presently available under PWD Mechanical Division. Lordship, me kindly come to page 47. This is the reply, Lordship. This is reply dated 6 August 2025. Lordship, me kindly come to page 48. This is the list of candidates applied under commissioner ground till date. Now here, what will Lordship? The petitioner name is serial number 3. Lordship, may kindly appreciate one aspect, Lordship. In the year 2022, the petitioner name figured as serial number 1 in the commissioner list, Lordship. In the year 2024, the petitioner name pushed down to serial number 2. Now in the year 2025, again the petitioner name pushed down to serial number 3.
No, otherwise also. Otherwise, your father died 2014.
14.
12 years have passed. You have survived for these 12 years.
Lordship, I am claiming in terms of the scale formulated by the state government.
Yes, state what?
Lordship, at this stage, notice can be issued.
Yes, Lordship.
Yes,
But
no,
in this Lordship, protection will be given. Otherwise,
No
all
protection.
posts will be filled up by the government in other ways, Lordship. Other way. And no post will be given to the commissioner applicants, Lordship. Therefore, considering the conduct and the action initiated by the respondent during the last 11 years, Lordship, some protection may be given to reserve at least 3 posts for the commission applicant, Lordship.
heard Mr. Wati Zamir, learned counsel for the petitioner. Also heard Mr.
Ajungli Sangam.
Ajungli Sangtam, London government advocate. This writ petition has been filed by the petitioner, has been filed under Article 226 of the Constitution of India by the petitioner, namely Changki Sung Si Lusang, seeking compensate appointment in terms of the scheme of the government on death of his father. Your father died in harness?
on 12/10/2014.
Death of his father on 12/10/2014, who died in harness while serving as assistant mechanical engineer within bracket AME under the establishment of mechanical PW department, Nagaland Mokokchung. Stop. Issue notice to the respondents. Since Mr. You are appearing for all the respondents.
Lordship.
Since Mr. Ajungli Sangtam is appearing for all the respondents, no formal notice need to be issued. However, you have served the copies.
Sir, Lordship.
However, the requisite numbers of extra copies shall be furnished to the learned government council. Stop. Learned council for the petitioner has also sought for an interim relief by seeking by keeping at least 3 posts out of total 11 available vacancies in Group C and Group D to be reserved for consideration for compassionate appointment. Considering the fact that the petitioner's father died in harness about 12 years ago, and considering the submissions made by learned, you will be filing additional affidavit. Affidavit in opposition.
Lordship. 4 weeks, Lordship.
Considering the submissions made by learned government council, whereby he seeks 4 weeks time for filing additional affidavit in opposition. This court is not inclined to grant any interim relief at this stage. List this matter after 4 weeks.
I've stated in my paragraph 16 that respondents are contemplating to fill up this 11 posts. So considering as a
When?
Lordship, paragraph 16 of my petition, Lordship.
When they are
Lordship, that the petitioner beg to state that the petitioner learned from reliable sources that the
no.
government is contemplating to fill up 11.
Is
11
whether any
vacancies.
advertisement issued?
No, Lordship.
Then in how they are going to fill it up?
All 121 posts which were filled up during past 11 years. No advertisement.
No,
That is why.
how
Advertisement.
how you came to know that they
Through the
are?
RDI, I have a documents furnished to the RDI only on the strength of the government approval. That is why I'm praying for a hearing, Lordship, that
No interim at this stage. List
but
accordingly.
once the post, second post are filled up, Lordship, then there will be problem for the petitioner, Lordship.
No, you are coming to this court after 12 years seeking compassionate appointment. That itself makes your case very weak. I don't want to reflect it in the order sheet.
Otherwise, two of my junior applicants have already been appointed. It is a part of record in the.
Let them file their affidavit in opposition.
Order be because the pendency of the writ petition shall not be barred to consider case of the petitioner.
Yes, yes. The pendency of this writ petition shall not be a bar to consider the case of the appointment for, consider the case of the petitioner for appointment on the ground of compassionate appointment
The is.
in the available vacancies. Yes.
For motion, item number 27.
Lordship here. I'm seeking appointment on land ownership basis. As well as I'm challenging the selection process of screening committee. And impugn approval and appointment of prime minister number 5. Should the case will be listed.
Okay, we'll issue notice.
Lordship, I'm challenging and praying for interim as well.
What interim?
For stay or impugn approval and appointment of respondent number 5.
Respondent number 5 is not before us. At least he deserves the notice.
Yes, Lordship. However, if we see by the reports, the screening committee was not constituted
No, we'll
in
consider
terms of the OM as well as.
that we will consider in the writ
Yes,
petition.
Lordship.
Let the respondent number notice be served on respondent number 5.
The screening committee has recommended another person. However, the respondent authority, he has appointed respondent number 5 illegally. So even though respondent number 5 has already been appointed, however, she was appointed illegally. So I'm praying for stay.
No stay at this stage.
Your Lordship, at this stage, let notice go. As for the interim, let it be subjected to the outcome of the main petition, Your Lordship. Petitioner has already been appointed in the month of March, Your Lordship. 4 months has elapsed.
Has he joined?
That, Your Lordship, I have no instruction. He must have already joined. Because 4 months has elapsed, Your Lordship.
Heard Mr. Isinlo Him, learned counsel for the petitioner. Also heard Mr. Miss A. Aimi, learned government counsel. This application under Article 226 of the Constitution of India has been filed by the petitioner, namely Seineko, who is seeking a direction from this court for his appointment as in which post?
Beautiful appointment.
As medical attendant on the basis of land ownership. He is also impugning the constitution of screening committee as violative of the office memorandum issued by the government, as well as the appointment of respondent number 5 as medical attendant in Sepima Sub-Center, Office of the Chief Medical Officer, Dimapur, under Health and Family Welfare Department. Let the notices be issued. Since Ms. A.I.M.E., learned government counsel, has received notice on behalf of, received notice for the respondent number 1, 2, 3, and 4, no formal notice need to be issued. However, requisite number of the copies of writ petition along with annexures may be furnished to learned government counsel. Let the petitioner shall take steps for issuance of notice upon the private respondent, that is respondent number 5, within 7 days from the date of this order by registered post with AD as well as by usual mode. Returnable after 4 weeks. List accordingly.
Publish.
For admission, item numbers 28 and 29.
Yes, yes, Mr. Ing.
Lordship, I have not received any instruction from the central government ministry. However, I rely on my arguments, placing on the documents which are placed before this honorable court.
Yes,
Now, Lordship, this matter, in fact, 7(6) are reserved for the employees of the central government. This issue has not been raised before, because this is the first time an employee, children of an employee of the central government, they have a abortion school. So this is the first time the matter has been come to before the court. Otherwise, if there was any candidates from the central government employee, we should have been settled long time before. This year, 2025-26, is the first time an employee, children of the central government employee has abortion school. Lordship, there are a number of documents of the central government, but I will just rely on one document, which is at read petition number 138.
page
Page 28
of the writ petition.
of the read petition. Read petition 138, page 28.
Yes. That's the
Yes, Lordship,
letter dated 9th December.
this document has been, the guidelines has been followed time and again by the central government, and 24, 25, these are all regulation of the 2019-86 guidelines, Lordship. So I will rely on this only. I think if necessary, I'll rely on our other. But for now, I'll rely on this. This page 28, Lordship. This is issued by the Ministry of Health and Family Welfare, Government of Nagaland, New Delhi. Dated
Government of India.
Government of India, New Delhi. Third. Dated 9 December 1986. And then, and in all these years, this has been followed by the central government. May I read, Lordship? I will not read, this has been referred to by my United Council, senior councils. I will not go through all this. It's just page 2, but dear sir, sorry. Yes, sir. I'll read again, Lordship.
Okay. What is your stand?
My stand is that 42 seats are allocated by the central government,
For
which
this-
is called Central Group.
Yes.
No, I'll just read two paragraphs, Lordship. Three
Yeah,
paragraphs.
yes,
This
please.
is a repetition, but I'll just read
Please.
this. But my Lordship may kindly bear with me. As you are aware, you have been allotting BDS seats to your state, union, territory for the selection and nomination of eligible candidates. Some instances have, however, come to our notice that some of the allottees agencies have not followed the relevant instruction issued by the government of India while selecting the nominating candidates against the seat allotted by us. Lordship, this is very important. Against the seat allotted by us. That is the 42 seats. Then I can, Lordship may come to, I will not, then this 2 and 2, I will not read, Lordship. I'll read 3. Because this is already written out by the, so I'll read 3, Lordship. The children of the central state UD government employees mentioned above should be treated at par with the local resident. The sole criteria for selection will be the academic merit of the candidate, subject to any special orders issued by with the concurrence of the government of India. Then Lordship may come to 7%.
Yes.
It is requested that the above criteria for the selection and nomination of the candidates against the MBBS seat reserved, Lordship, the word reserved for the central government should be strictly followed. For that, Lordship, this reserve seat, reserved for the central government, that is, in other words, it is called central pool. The term central pool. So this 42 seats are from the central pool, which are meant for the central government, who children of the central government, in fact, children of the central government who is stationed at Nagaland, state of Nagaland. So this seats
Where have you read that strictly, it should be strictly followed?
reserved, Lordship, 7.
Where?
Reserved for the central.
Para 7.
Para 7. Para 7. I will read again, Lordship.
Yes.
It is requested that the above criteria for selection and nomination for candidates against the MBBS seat reserved for the central government should be strictly followed. So if my Lordship may come, the total number of seats for the Nagaland is around 152. I'm not very sure the exact number, I do not know, Lordship. Comes around 152, Lordship.
Yes.
So out of that, 42 seats have been reserved as a central pool. And this 42 seats are meant for the central government who are stationed at central at the state of Nagaland. Yes.
Where are these 152 seats? In which colleges?
There are different colleges. We have at somewhere around 80 in Nagaland.
These 152 seats are in Nagaland only
No. In different parts
of India.
80 seats is around at Nagaland Medical Institute, and the other seats are from different states. Different states. So 80 seats, 152 minus 80 is from the Nagaland Government Institute Medical College. Others from the central government are from the other state. So out of that, 42 seats are exclusively reserved for the central government. So, however, Lordship, these 42 seats have been reserved for the central government since the last year, Lordship. However, there was no candidates from the central government, children of the central government employee. So the present issue has not been raised. Because none of the central government employees, children of the central government employees has come forward. This is the first time. This is the first time the petitioner is approaching before this court. So the state government was of the opinion that since no central government employees has come earlier, this seat are reserved for the state government. However, it is not that. It is the exclusively meant for the central government.
Suppose there is no candidate.
There was no candidate earlier, Lordship.
Yes.
There was no candidate. No one has applied.
To whom these seats would go?
The seat was allocated to the children of the indigenous inhabitants of Nagaland.
Okay.
No, there was no claimant earlier. This issue has arose only because for the first time, the petitioner father, who is an employee of the central government, has approached, and this is why this matter is before you. Otherwise, since there was no claimant from the central government employee, this issue has not been raised. So this is the first time. Otherwise, all those years, both should have been reserved for the central government employee. But since there was no candidates, the issue has not been raised. And all this time, the central government, as the state government, was of the opinion that the seat belongs to the central government. Otherwise, that's not. if my lordship may, I'll just refer to page 32. Page 32, annexure E. My lordship,
Page,
page 30, annexure E. Subject, this is dated 31st August 2016.
yes,
I'll just refer to the subject lordship.
yes,
Oh, look, it is almost same, so I'll just refer to the subject. Allocation of Central Pool MBBS seats for the academic year 2016 and 17 project. So similar order has been, notification has been issued from 2024 or 2025 also, but I'll just write here. In all this notification, the word has been used, allocation of seat from the central pool project. Central pool MBBS PDS seat. But since they're all on our repetitions, I'll just every time the central government has issued notification of guidelines, the word central pool has been used, which means reserved for the central government. So these seats are reserved for the central government employee, children of the central government employee. Lordship, I'll come again.
no. But go to page 28. The
28, yes,
letter dated 9 December 1986. It refers to 4 categories of persons who are eligible to get.
Which
First one is the permanent resident of the state and UT concerned.
yes, para two, Lordship.
Para 2.
Yes, it is one again regulated that only the children, permanent resident of the state UT. 2. Employees of the state UT government concerned. The employees of the central other state UT on deputation of the state concerned. 4. The employees of the central state UT posting in and having a headquarters within the state UT concerned will be eligible.
Yes, it is not only central government, but
This is not only for central government.
3 other categories are also.
Yes, but we are now concerned about the central government employee. So it says the seats are reserved for concerned children of the central government employee. That's what I mean to say, Lordship. So these seats are reserved. If there is no candidates from the central children of the central government employee, ultimately these are filled up by the non-indigenous inhabitants. Out of that 42 seats. But when there is candidates from amongst the children of the central government, this should be the
No, then if there are candidates among of the wards of employees of central government,
that is what I'm saying.
then it has to be on the basis of merit.
Merit will come, Lordship. We are not talking about merit. Yes.
These 4, to my understanding,
What I mean to say-
these 4 categories stand on same footing.
Yes.
Whosoever is more meritorious would
Yes,
get.
we are not talking about the merit now. She has merit, because we're not talking about the merit now. But what I want to say, only for the merit, yes, only for the merit student it will go. But the reservation of seats are already reserved for the central government employee. So I will not go to the different categories of central
No,
government.
there is no reservation for central government.
No,
employee.
this is said, para 7 says reserved for the central government. Is
But para 2 says that 4 categories of
yes,
candidates.
categories means permanent resident of the state. 1, yes. For
Central government,
employees of the state, yes.
wards of central government employees
Employees
is one of the
state.
category.
Employees of the central government, other state also. The unit territory also there. Government on deputation to the state unit concerned. So if there are employees of the union territory in Nagaland, they are also eligible.
Yes.
Yes, from the union territory. If they are employees from they are sent to deputation on Nagaland, they are also eligible. Likewise, government.
So amongst all eligible candidates
Yes.
who are paying for allocation of seat
Yes.
out of central pool,
From the central pool. That's right.
out of these 42 seats,
Yes.
whosoever is more meritorious would get.
Yeah,
Suppose-
yes, that it comes to meritorious, so I will not say whether the petitioner is merit or not.
No, I'm not going for the petitioner's case. That is the what notification says.
Here it says meritorious. It says the.
In para 2, it lays down the eligibility criteria.
Yes, that is what.
Which categories are eligible.
Yes.
And then it says that selection should be on the basis of merit amongst those who are eligible.
Amongst those who are eligible, Lordship. I do not know of whether petitioner is eligible for this or not. Let them prove that it's whether she is eligible or not. But I'm talking about the eligibility.
Okay.
I'm not talking about merit, Lordship. I'm just talking about eligibility here. So what I want to say is 42 seats are reserved for the central government employee. And
According to you, 42 seats are, all 42 seats are reserved for central government employees.
Yes. So, Lordship, I think this one there is a document, Lordship, which has been placed before you earlier also by the state government. With my Lordship, I think this document is with the before your Lordship.
Which document?
This is not there. That's a seat distribution.
Yes, seat distribution.
One single page, Lordship.
But find it out. Find it out. Yes. Now,
Your
what is the
Lordship,
submission?
Your Lordship got it.
Yes, you can. I
Yes.
remember.
Here, Your Lordship, this has already been referred to, but I'll just want to refer it again, Your Lordship. Seat distribution of central pool. This is document of the central government, Lordship.
Yes.
Here, if we come to Nagaland, 42 seats have been allocated.
Yes.
Yes. And like for the Ministry of Defense also, 42 seats have been allocated. So these are all reserved seats for the central government employees. So who are stationed or who has been on duty.
Now, whether the petitioner is the children of central government.
I don't know about that. I don't know about that. Let the petitioner prove
No,
that.
no. Have you not been furnished with the copy of written
I have.
petition?
I have.
What is your stand?
My stand is that Fafara is Colonel NCC,
Yes.
which means he is also one of the central government employee. I do not exactly know the estimate, but the affidavit says, in the affidavit, it says the petitioner begs to state that the treasurer of the petitioner being posted here in the state of Nagaland as a commanding officer of one Nagaland battalion
No.
NCC.
Okay. I just want to know the stand of the Union of India.
Yes.
That the
So
petitioner.
what I will say, he says, I don't know. If he is.
You cannot say you don't know.
It says he's a commanding officer of the Nagaland.
So what is the stand of the Union of India? That petitioner is the daughter of a central government employee.
If he is a commanding officer Nagaland STC, then he will be the central government employee.
Okay.
That is from the report project. It says that he is the commanding officer of the first Nagaland NCC, Nagaland Battalion NCC. So it means he is the petitioner father is the central government employee. That's why if 42 seats are exclusively reserved as central pool, this central 42 seats should be reserved first for the central government employee. If there is no candidates from the central government employee, children of the central government employee, this seat should will ultimately be occupied by the non-indigenous inhabitants. And this has been done for the last 4 decades. This seats has been filled up by the non-indigenous inhabitants of Nagaland because there was no candidates from the employees of the central government. All this time, no problem, because there was no candidates from the central government. This is the first time the central government, children of the central government employees has approached this scope that this 42 seats are reserved, and these are reserved from the central pool. And this, in fact, should go to me. It should go to the petitioner if she can prove that her father is an employee of the central government.
Okay, what is your,
That's just-
what is your stand on the notification dated 9 September 2021 issued by the government of Nagaland?
But page number or
Page 142.
yeah, yes, Lordship. This Lordship, this come under medical education. So under Article Schedule 7 of the Constitution of India, there are 3 entries.
No, whether it is in violation of,
That is why I'm coming,
The-
Lordship. That is why I'm coming.
yes,
Under the Schedule 7, there are 3 lists. One is the central list, one is the state list, one comes under concurrent list. Education comes under concurrent list. Concurrent list means
okay.
both central and state can be legislated. However, the word concurrence, Lordship, word concurrence means central can also legislate on the issue, on the topic, particular topic. State has also the right, but concurrence should be second from the central government before issuing of any notifications. And if the subject falls under list 3, and as I stated, education fall under list 3. Both central has the power, state has power, but concurrence from all the parties should have taken before.
Whether any concurrence was
So,
obtained.
my only thing is this order has been, this notification has been issued by the government of Nagaland Higher Technical Education. And as far as I can see, the copy has not been furnished to the central government. That is why I'm saying, Lordship, I have not yet received any instruction, and it's relying on the documents that is in place before this honorable court. So from page 143, copy 2, they have not endorsed any documents this to the central government, so central government is not aware as such of the existence of this notification.
Okay.
That is in short my submission. Lordship. Because all the submission has been like they have referred to all the documents, the documents that has been all been relied on, has already been relied on by my letter trade. Okay, if any clarification is needed, I'll clarify it.
Okay.
Otherwise, my submission is that person.
No, Ms. Shukri, whether is there any time limit for sending the list of nomination for admission against central pool?
Yes.
What is the time limit? To whom you will be sending these,
To the Ministry of Health and Family Welfare.
and then they will approve that list.
Yes, Your Lordship. So far, we have been sending the nominated list to the.
You will also indicate to which college you are nominating a particular
Yes, yes,
candidate.
Yes.
Suppose there is a college at Delhi. You will will you indicate in your list that this candidate is
Yes, yes.
nominated for this college?
Yes.
And then this list will be approved. What the central government will do?
After we have done the selection and the nomination against the particular colleges chosen by the concerned candidates. After that, we prepared the list and we sent to the Secretary, Ministry of Health and Family Welfare for information. So all along, we have been doing the same procedure.
No.
We have not even received any complaint from the central.
No, what is the process thereafter? When
Sorry for the interruption, Lordship. There was no complaint from the central government side because earlier
no,
there was
okay.
no
This is the
candidate,
first time.
one has applied. This is the first time
Okay.
and children of the central
Okay,
government.
no, I am on a different,
Yes.
my query is different.
Yes.
Once the list is prepared and sent to the central government,
Yes,
then central government will forward it to the college.
yes,
There, the candidate shall have to report,
yes,
and then he has to take admission
yes.
in this.
The matters ends there, Your Lordship.
So that college will keep that post vacant. It will not fill it up.
Lordship, what my learned CGC has submitted is totally deviation from its own record. If we see that the central pool seat meant for the state of Nagaland is 42, we can say that that is a special package for the state of Nagaland, which we are deficient in medical profession.
No,
as
but
to that
it
medical
is for the
profession.
state of Nagaland for 4 categories of persons mentioned.
Yes, it is mentioned, Lordship, but even here also it clearly says that for the deficient state, Lordship, I'll take you to my bunch of next year. The intent of this scheme, Your Lordship, the object and the intent of this scheme.
One bunch was given.
The bunch of yes. Yes, page 20, Lordship. Lordship, the intent of this scheme is clearly mentioned on page 20. Page 20, guidelines for selection and nomination of candidates against Central Pool MBBS BDS seat for the academic year 2024-2025. Selection of candidates by beneficiary state union territories. 1.1. Beneficiary state UT. The state UT which are deficient in medical education. So
Yes.
if we take the submission of the central council, that is totally exclusively reserved for the central government.
No.
And that's what he has been saying.
No, he's wrong.
Yes, so it is wrong. Why the intent, the objective of this scheme is that
Central government ward is one of the category
Yes.
out of 4 categories. But can they be excluded?
Yes.
What you are, yes, please continue.
this is for the benefit of the state of Nagaland to come at par with the rest of the state. And we have been getting the central pool seat since a long time back. And the Ministry of Health and Family Welfare, they have never raised any question. And Lordship, we have also placed the record that even 42 seats are reserved for the children of defense personnel. We have shown yesterday.
No, therefore I am putting question. Suppose a person is eligible under more than one category. So it is his option for which category he may.
Okay, if it is his option, he has to qualify in the eligibility criteria. But when she could not qualify, Lordship, whether she can file a case.
No,
Like
you have. Okay, then you have put certain additional eligibility criteria, and the central government notification guidelines mandates that if you want to put some special conditions, you have to take concurrence. How you have taken concurrence?
What my learned AG has relied on, that is the judgment of Dr. Tanvi Behel at page 23.
Help me. Yes, what it says?
At page 23 in the middle para, at the same time, it must be realized that you cannot allow people who are flying from one province to another, from one state to another as mere birds of passage, without any roots, without any connection with that particular province, just to come apply for posts and so to say, take the plum and walk
No,
away.
is it your submission that the petitioner falls in that category?
Lordship, she would fall under the.
In that category, no, in that category about which the judgment in the apex court is referring to in Tanvi's case.
On the domicile, Lordship. But what the learned apex court says that for the domicile, it is permissible, Your Lordship, in the undergraduate, but not in the postgraduate. That is very clearly said in
No, that is not my query. You may put any special condition regarding domicile.
Yes.
But for that, concurrence of the central government is necessary. Where is that concurrence?
So my learned AG has replied to you yesterday. Because you raised that question also, and my learned AG has replied to you on that question yesterday.
His answer was no, that till date, central government has not raised any objection. That was his answer.
Yes, so I cannot deviate from what he has stated, Lordship, before the
Oh,
court.
okay. Okay.
So, Lordship, what the learned CGSC says is totally in contradiction to its own record. And we have to know that the specials involve the beneficiary state of Nigeria. We have to see, consider the case in that light. So that we are deficient in medical education and infrastructure. So these central pool seats are given to us. And the petitioner, also she has other option in the 42 seats of children of defense.
Okay. Oh, you have not answered my query. What is the time limit for sending the nominee? When the session starts?
After the admission start, 7 days after the admission started.
No,
we
when
send
the session starts of the first year.
It's an ongoing admission process. The last date of admission is.
Till what time admission will continue?
18th of August, this year, 18th of August. This month, 18th of August.
Who has put that deadline?
Lordship.
That 18th of August.
That is as per the Government of India directive.
Ministry of Health and Family Welfare.
That means before 18th of August, all
All
Pro-
the selection process.
has to complete, done. All seats are to be filled up before 18.
Yes. And if seats are filled up, we have to return the seat to the Health and Family Welfare, to the MCC.
What will happen to those seats?
That too, we do not know what the discretion the MCC will be.
No, seats which remains after completion of the first round of the completion of the, suppose on 18th of August, some candidate does not take admission. What will happen to that seat?
Second round and the third round.
Of, that means after 18th of August also,
Yes.
eh,
The last date for the third round is.
okay, let me understand one more thing. Miss Sukri. Suppose a seat has been earmarked in, say, a medical college in a place, say, Jaipur or Jodhpur, a seat is there out of these 42 seats. Till what time that college will keep that seat vacant? Because till now, the nomination has not gone. So they will wait till 18th of August.
We have sent the nomination, Lordship. So it depends on the colleges, whether they will have the last, or which date will be the last date for admission. So our admission are still.
You have already sent the
We
nomination.
already sent nominated candidates.
Then there was a direction that one seat should be kept reserved.
Yes, seat.
You have kept one seat reserved
Yes, one seat reserved.
in a specific particular college.
No. Have not just that, just reserved one seat.
Where will be that? Because out of those 42,
That's the one.
okay, this is the nomination.
Yes,
Okay, no, before, I, I don't want to open it if it is not required. Only if it is required.
plus the vacant are there, inside the sealed envelope.
No,
It's mentioned.
I want to understand one more thing, very basic thing. Central government has allocated 42 seats for the state of Nagaland. Whether these 42 seats are earmarked in particular colleges,
Yes, yes.
whether that has been told to you.
What can I be now?
108. No, it mentions total seats, 42 seats from central pool for this. From
It, it's already going on. It's already in the writ petition also here. Roshit, these are the seats.
this 1 to 1 to 30. One to 30.
There will, I think it continues in the next page also.
No, you are saying about only 42 seats.
1 to 42 will be the central pool seat.
1 to 42 central
Yes.
pool seat.
1 to
So that means you know where the seat is kept vacant for the. You need not to tell in the open court,
Yes.
but that is known to you.
Yes.
Which college you have kept.
Mm.
Now, how colleges are allocated on the basis of
Merit.
preference
Preference.
as well as comparative merit. Suppose
Yes.
I am selected. I prefer for college number 1, 2, 3, 4. And a more meritorious student prefer for same colleges. He will get the preference number 1 first.
No, on the day of the counseling, Lordship, the merit number 1 will be called and the preference, she will take that preference.
It will be given and it will be cut.
Yes, expert the merit serial, she will take. So if I'm in the middle of the list, if I prefer a choice also, but if that is already taken, then I have to opt for another. Yes.
Okay. So, if this court opens this seal envelope, which I am very reluctant because it is not yet, whether this list will be published. You have sent that you have stated that you have already sent the nominations to colleges. So before that, whether this list is required to be published.
Has become public now. Now that it is sent to all the colleges, I mean, to be given to the candidates themselves. So what more secret?
The final list is already out.
Where?
Yes, submitted.
No, this is in seal envelope. How the candidates will know?
Because they will accept the nomination. They will take the nomination paper and they will go to the concerned college and take admission.
So for that, they have to be made known, aware.
They are aware of it, Lordship.
So they were told.
Yes,
These 41 candidates have already been told that which seat has been allocated.
Lordship, to answer your query, Lordship may allow the concerned officer to.
Yes, yes, yes.
As per the state councilling held on 4, all the candidates, as per the merit, they have been allotted the seat of their choice. So they have taken their nomination letters and they have proceeded towards their respective colleges for their admission. And now the state will.
When they have to report?
They have started going. They have already, most of them, they have already gone and taken admission also.
Okay, so this list need not to be approved by central government.
So after that, the direction of the central government is that after they have taken admission, we will have to submit a list within 7 days to the central government. It is in the guidelines, sir.
After taking admission.
Admission, yes.
Suppose somebody does not take admission.
So we will, if there's a time for admission, that the student will report to us. So we'll have to renominate as per the merit.
Okay.
Yes.
Till what time that process goes on?
So the process will be done, if there's we will see whether the admission period is there or not. If there's no time for students to be allotted for, the timeline is over, then we will not be able to nominate.
No, that I want to know. What is the timeline?
So, sir, your Lord,
You can address.
right now, the admission is going on, and then there are different rounds. So the admission period for some colleges is 18th of August, and some colleges were yet to get that because the
So
round.
those colleges have intimated to you that this is our last date of admission.
It is
So
intimated.
please instruct the candidate.
Yes, it's already instructed.
Okay.
Yes.
So where I will know which seat has been kept vacant?
It's
In this
mentioned
field?
there in the envelope.
Okay.
Yes.
Okay. Suppose the
Yes.
petitioner gets a favorable order in this writ petition. You will have to intimate to the petitioner that this college has been allocated to you.
The petitioner will come to the office, and then the nomination letter will have to be given to the petitioner. If
Okay.
it goes, yes.
And suppose this writ petition is dismissed, then to whom?
So now there are candidates waiting for this particular seat. The next merit.
Who are in the waiting list?
So there are some candidates who haven't taken that NIMSA college, and they are waiting for GI seat in the merit. Yes, in the waiting list. Yes. So that vacancy will be offered to the candidate who hasn't taken. There are some candidate who has been provisionally selected, but they refused it because they wanted the GI seat. So that candidate has been identified, and we have kept them.
Okay.
Yes.
So you have also identified the candidate to
Yes.
whom it will go in case of dismissal of this.
Yes. Because the application has come. The application has come because that they want to take that seat in case, yes, it has been offered.
Okay. Okay, this much. Yeah.
Lordship, my last, I may be allowed to read again, WPC 134, page 21. My learned AG has also submitted his bid,
WPC?
134. Page 21.
My lord, learned advocate general has already made submission on this point, so it will be a repetition.
No, just
No, but
if it is a repetition, I may not allow.
Yes,
But page?
page 21. To reiterate what he has submitted,
Yes.
to make the case more clear. Lordship, this is dated 31st August 2016. Come to point 2. Further, the following points may also kindly be kept in view in this benefit, Lordship.
Okay, okay.
1. The admission of candidates to various colleges will depend on their fulfilling the eligibility criteria, conditions of admission, and other requirements as laid down by the concerned institution, state government, which may be asserting from the concerned college. And even if your lordship come to point Roman 4, the intent and the objective of the scheme of 42 Central Pool Scheme is also clearly mentioned. Since the purpose of Central Pool Scheme is to make available qualified medical professional in the medical beneficiary state UT. Therefore, it has been decided to instruct all the beneficiaries to ensure that its selected candidate to execute a bond undertaking to serve in the respective state UT for a minimum period of 5 years after completing graduation. So the intents and the objective is clearly mentioned here, Lordship.
No, I have a query. Out of these 42 candidates, whether each one of them have to fill up a bond?
Lordship, they have to fill a bond. Yes, they will. Surety bond.
So the central pool candidate, if he's a children of central government employee, he has a,
Local also they have. The local also they have to sign the surety bond. Even the Naga, indigenous Naga also.
no, I'm not speaking about indigenous Naga.
Everyone.
Those who are not belonging to this state, they have also.
Yes. Till now, no one, Lordship.
Yes, that Mr. Yangarwati has
Still one, no one, but if at all there is, they will have to sign.
signed bond
Yes,
to serve the state.
yes.
Then what is the difficulty?
No, Lordship, we have to go through the,
Now,
Well-
how it comes to, how it goes against the petitioner?
the reservation policy and even.
No, this 4. Number 1, number,
Lordship, petitioner has to qualify the eligibility criteria.
yes, that may be,
Fulfills the eligibility, only then she can.
and
Yes.
your submission as well as submission of the Advocate General was that on the date when she applied for this medical NEET examination, she was not eligible according to your notification dated
Yes.
September 2021.
What?
She failed to fulfill those two criteria.
Yes. So your lordship, now she is all India ranking is 1,13,803. It's sad to say, but she could not get in other state. So she is targeting trying to grab the opportunity that is meant for the state of Nagaland, lordship. That is the saddest part, lordship.
No, but her father works in.
No, but even if her father works also, her father has not completed 3 years. And the petitioner also
That
has
is-
not studied here.
No, that is the contention of the counsel for the petitioner. This additional qualification which you have included is without the concurrence of the central government. That is their plea.
That anybody from anywhere can come and take the seat which is meant for the state of Nagaland. And where is the question of uplifting the medical professional from that concerned state?
Okay.
Yes. That's all.
Yes, Mr. I am fixing time for you. 15 minutes.
15 will be too less, Lordship, because I have 13 points, 2 minutes each I will take for 13 points, Lordship. So at least for half an hour, they will permit it. If possible, I'll try to finish before that.
Okay.
So in any case, I will not cross the first half.
Not first half.
If I don't finish, Lordship may stop me also.
No, I am stopping you now. At 12:30 you have to stop. Half an hour.
Lordship.
Mr. Imchen, you.
Yeah.
Who is appearing before the state? Learned Advocate General has submitted on earlier occasion, Mohammed was appearing. And then additional Advocate General is appearing. I do not know who is representing the state.
I'll give you your half an hour time.
Lordship. And
Yes, Mr. Imchen. You have anything to add which they have not stated?
Talking about this 9/9/2021 notification,
Yes.
which has been produced by the state. It was penned, formulated in 2021. Your Lordship, please appreciate that, 2021. So in order to formulate that notification, we don't need the permission from the Union Ministry. Because Your Lordship kindly appreciate we have a concurrent list. And on the basis of that law, we have formulated. So if you take a proposition that we need to take the permission of the Union Ministry in order to formulate our notification, which is 9/9/2021. It is not a tradition that every notification formulated by the state has to be taken consonance, permission of the Union Ministry. That is what I want to add. We have not taken the permission of the Union Ministry for formulating our notification 9/9/2021. Because it is not required. Where is the law?
Even if it is repugnant to 1986 guidelines, my query is, their stand is that it is contrary to the guidelines issued by central government.
It was existing since our notification was existing
Yes.
since
On that point, they have
2021.
made submissions.
Guidelines are just directory only. Guidelines are directory. It is not mandatory, Your Lordship.
Okay, one more. Where have you published this? How a candidate aspiring to apply for central pool, how he would know what
We publish in the newspaper, in the portal, in the website. Yes.
this,
Even the petitioner has also annexed those documents. also.
where? No, this 9 September. 9 September,
Lordship, you mean the 9th September 2021?
9 September 2021, which lays down those additional qualifications. 9/9/21.
Lordship, it's in the portal. If you come to page 142, we have sent to all for publication in the Gazette, Lordship, everything. 143 of the WPC 138. Lordship, so once we have published in the Gazette,
No, why
it becomes official.
I'm raising this plea because there was a submission made by learned senior counsel for the petitioner that he came to know about this only in this court when you produce it.
So for that matter, my learned AG has replied that ignorance of law is not acceptable, Your Lordship.
No, therefore I'm asking,
We have already published in the Gazette. So once we have published in the Gazette, it becomes final, Lordship.
when?
And when they approach the department, the department concerned also intimated to the petitioner that he is not eligible because of this notification.
Okay. When the department informed,
Lordship,
when department informed the petitioner?
the date of her submission of application. On her date of her submission of application. And Lordship, I'm constrained, but I restrict myself, but I'm constrained to point out. Lordship. The conduct of the petitioner, Lordship.
No, before that, you will submit what you intend to.
Yes.
Where the application for admission has to be first, is it online submission of forms?
It's an offline.
Offline. A candidate has to submit forms where?
To the office, Lordship. It's already. We have the hard copy, they have also annexed, Lordship. The Directorate of Higher Education. Lordship, if you come to page 138, page one.
No, your submission is that you have informed the
Yes.
petitioner.
That information is here, page 123 of WPC 138.
Page number,
123, Lordship.
yes.
This is 24th July 2025. This is notification. Number such and such on the recommendation of the State Common Selection Board, the provisional selected candidates to fill up Nagaland State Reserve seats in MBBS, BDS, such and such courses for the academic session 25-26, based on the NEET UG 25 merit has been declared and uploaded on the department website such and such. The provisional selected candidates on all the remaining eligible candidates of the state and NEET undergraduate 2005 merit lists are informed to attend the state counseling schedule on 30 July 2025 at 10:30 a.m. in the conference hall of the Directorate of Technical Education, Nagaland, Kohima, without fail. Important one. This is a provisional selection result and is subject to change depending on the availability of anticipated seats and option exercised by the candidate. 2. Failure to attend the state counseling shall be assumed as declined and their candidature for selection and nomination to MBBS and allied courses and BVSC and
No,
forfeited.
this was not my question.
Yes.
When you informed the petitioner about 9 September 2021 notice?
For that, when she submitted her application, Your Lordship, they have not annexed their submission of their application in the documents, Your Lordship. If at all they are relying on that. They have not submitted their application. Lordship, for every candidate, whoever comes and submit their application, if they comes under category 3, we inform them.
Orally.
Yeah, orally. Yes, orally. Even close.
What was the date of submission of application?
From 21 May to 31st of June. 30th of June. Form submission. And Lordship,
Yes.
they have also annexed the documents in the writ petition that is at writ petition 134 at page 98. Page 98. This is a list of category 3 and rejected candidates for Nagaland State NEET undergraduate 2025. Number 1 is the petitioner name.
No, this they know. This is about,
Chief, they come to know about the notification 9921, which debars the petitioner. That is why they filed the 138, read petition 138, and challenging that 992021.
no, there in the writ petition itself, they have stated that they came to know for the first time.
Lordship, once we publish in the
Okay,
Gazette,
that is your stand,
Yes.
that it has been published in.
the duty of the officer to serve each and every document to every candidate. No, Lordship, they have to be diligent enough to search if they are going to apply. What are the criteria? What are the eligibility for that concerned state?
So your submission is,
The duty of the petitioner, Lordship.
so as it is published in the official gazette, they could have challenged it earlier also.
Lordship,
Before applying, they could have challenged.
only if she passed the need, only otherwise, only if she is eligible, only she can, Lordship. Because she would not have any enforceable right.
Okay. Okay.
Lordship, I restrain myself not to point out, but now I'm constrained to point out, Lordship. Lordship may come to the affidavit in opposition to our IA.
Yes.
Lordship may come to page 23. This is the application by the petitioner on 1st of August 2025. As per the procedure, she is not supposed to submit her choice prior hand, Lordship. And if we see she is using the seal of her father, which shows she is abusing the power of the post of her father without authority. And even in page 24, the petitioner is using the seal of her father without authority, Lordship.
No, where is the seal?
You'll see Nagaland Battalion NCC.
Right.
She is not an employee of the NCC, Lordship. So she is abusing the authority, the power without authority, Lordship. So that shows that in order to drag the precious seat meant for the stake of Nagaland, Lordship, she is trying everything, Lordship. That also has to be taken into consideration. So, Lordship, much obliged.
Yes, Mr. Zamir. You have exactly half an hour.
Yeah, pleasure, Lordship. Before I reply to the submission of the Learned Advocate General, two things I would like to clarify, which your Lordship has made query just now about the submission of the application, and the department has tried to mislead this honorable court by saying that whoever comes for submission of bill application under category 3, then we used to inform. No information was given, but they have accepted and everything was done. That is the reason why it was not uploaded in the portal of the department also. On 28th, when the writ petition was moved unlisted, and that day I pointed out this fact that, look, without any basis they are showing it. And that day, incidentally, it so happened that department was so quick, they have furnished this notification on 28/7/2025. So I came to know on that day. So I was constrained and compelled to challenge this notification. Subsequently, in WPC 138. So the father of the petitioner is also here, who went personally and submitted the application. Nothing was informed to him. He is also here. If Lordship permits, then he can say that, whether he was informed or not. About the existence of notification of 9/9/2021. Because the officer concerned has already informed this honorable court that we inform to all the candidates whoever comes for submission of forms.
What is your submission counter to the submission made by additional AG that once a notification is published in official gazette, it is presumed that it is in the public
That
domain?
is with regard to publication of the notification. Whether that is valid or not, that is under question in this writ petition. Therefore, but the fact remains that on 28/7/2025 in the evening, it was uploaded in the website of the department of this notification. After I pointed out during the proceeding of the court, in the court, on 28/7/2025. So I have annexed that to show when they have uploaded in the department website. In WPC 138, I have enclosed that also to show that when they have uploaded different documents in the website of the department. It was kept secret.
Yes.
So far as admission procedures are concerned, Lordship was making that of query. Fact remains that this honorable court has passed an order directing the state respondents to reserve a seat, and there is a specific order that the counseling to be conducted and fourth shall be subject to the final outcome of the case. Department is well aware about the pendency of this two-writ petition and the order passed by this honorable court. The petitioners has already furnished a copy of the order to the respondents on the day of before the counseling also, which was to be held on 4th. And they are well aware that counseling has to be done in terms of the guideline laid down by the government of India, and which says that merit, the selection of allocation of seat has to be done on the basis of merit. So I have given my choice of colleges as per my merit. These are my choices. But what he did,
I'm putting a halt. Miss Shokri, you have to give me the dates on which the candidates were informed.
I have the document here.
No. Listen to my query. No, that is not my query. Query is after you finalize the list of nomination for 41 candidates, when have you informed them? Yes, please.
Your Honorable, can you kindly repeat the question?
You have finalized the list, final list of nomination for 41 seats, and you have reserved one seat vacant as per the directions of this court. And to my earlier query, you answered that the respective candidates have been intimated about their
Yes.
colleges allocated to them so that they can proceed. When have you done so?
On the day the counseling, on the day of the counseling, the candidate, all the candidates been informed. 4th of August.
Even the petitioner
Yes, was present on the day. Yes.
So to 41 candidates, you have already informed
Yes.
that you go to that college and
Yes,
take
yes,
admission.
Yes.
They might have taken admission also.
Yes.
Okay.
That is
Yes, please continue.
Lordship. So, in spite of the order passed by this honorable court, they are not ordinary people. They are the directors and the high rank officers.
No,
So
the order was there shall not be any halt to the ongoing process
Yes,
except reserving one seat.
yes.
That was the order.
Seat has to be reserved and the criteria for selection has to be on the basis of merit. So I have furnished the choice of colleges. So they are aware of all this. So they should have kept, if succeed, this college should be reserved in terms of the mark secured, option should be. I was not allocated any seat till date. So now, if I'm selected also, if I succeed, I will be allotted with the lowest rank seat. Because they have already identified as admitted by them today.
What is your submission?
Therefore, it has to be cancelled. And if I succeed, I should be.
No, if my query is certain things becomes irreversible after a certain point of time. Once admission has been taken, can it be reversed even if you succeed? The question will be dependent. Don't assume that you will succeed. I am not giving any judgment, but suppose if you succeed, then I want your assistance. How to tackle with this if you succeed?
Now that they have reserved a seat, at least one seat has been reserved.
Okay.
And before I reply to the Learned Advocate General's submission, one point for clarification with regard to the submission of my learned friend for CGSC, who made the submission on the concurrent list. Both center as well as the state has the power to make law on this. So that was in response to a query made by your lordship, and lordship is well aware about the implication of Article 244, the repugnancy, when two laws occupy the same field, one made by the center and the other made by the state. Obviously, it is the central law which shall prevail. So those implications are also there.
And
But-
one query. Ms. Shokri raised a point that the 86 guideline is not law, neither regulation nor act. It is only a directory guideline.
Okay. So, even if we don't comply with this, even if we don't apply these directives, there should not be any problem. That is what she meant that. Therefore, my query is, for what purpose 9/12/1986 was issued by the government of India? Just as a showpiece, not to be applied, or it was given direction to apply. It was given to all the states, and it is once again reiterated that it is clearly mentioned. Paragraph 1 and 2, very clear, in clear terms, the government of India has issued. This letter is issued after the Mandal Commission submitted its report way back in 1980. I will come to that in response to the submission of the Learned Advocate General. What type of a submission he has made? Now, but before I reply to the submission of the Learned Advocate General Lordship, I would like to clarify one aspect which occurred yesterday in the course of hearing. When the Learned Advocate General was making submission, I stood up and then tried to sought permission of the court. After going home, it has disturbed me a lot, thinking that as if I have done something unwanted and I have not behaved in a proper manner. I was disturbed. What I was trying to clarify was the Learned Advocate General was referring to a document of 12 August 2024. So as to have connection with a document of 13 August 2025, which is a part of the document which is enclosed in the WPC 134 as one of the annexures, so as to show that till last year, this was the instructions and directive and guideline of the government of India. Because on the day of filing the writ petition on 28/7/2025, we did not have the government of India order, which was issued on 28/7/2025. We did not have that on the day of filing on 28, because Lordship is well aware to file a writ petition, drafting is to be done first. Drafting was completed on 27th. So it was filed in the morning of 28 July 2025. And that day, maybe in the afternoon, an order was issued by the Government of India, Ministry of Health and Family Welfare, that the latest notification pertaining to 2025 and 2026 on 28/7/2025. Therefore, we have enclosed that document in the WPC 138 of 2025. Therefore, the document which my learned Advocate General was trying to show from a lost sheet, I was trying to project that, look, we have the latest and the relevant notification for 2025-26. That one is
This-
gone already.
This 28/7/2025 notification is similar to that of 1986 notification.
Yes, yes, same. So I was trying to project to the Honorable Court to save time and not to rely and refer to an irrelevant and unnecessary document. Look, we have already enclosed, and that is enclosed in page so-and-so of the second writ petition, that is WPC 138 of 2025. I was just trying to assist the court by showing the relevant document which is vital for deciding this case. But then there was a lot of reaction, and Advocate General was trying to stop me like anything, as if by succeeding that he will get Ashok Chakra. He was trying to stop.
No,
So
this court has not
the
taken any.
purpose of interfering was to
Mm,
assist the
no.
court and to guide the court.
Hey,
in a
Mr.
proper manner.
Zamir, I have not taken any exception to that. But when you interrupt, it breaks the flow. And sometimes advocates take this strategy intentionally also. Therefore,
Some may do that.
I'm not accusing you. Therefore, I requested you to take the notes and to reply later on. Because it would
Yes.
have.
Lordship, what Lordship has said, I'm very clear on that. Lordship has not interrupted as such. But then I was just trying to clarify this morning that the reason and the purpose, because as an officer of the court, I feel that it is my duty to assist the court in a proper manner. That was the only objective
Yes.
I tried to specify, Lordship.
Yes.
And I was expecting that the learned Advocate General will have a substantial.
You are utilizing your allotted this time from your allotted 30 minutes.
That allotted time will exclude the time taken by your Lordship also. And,
Yes.
as well as the state. Now, first thing first, Lordship, Advocate General has projected this argument in such a way which has been adopted by the learned advocate, additional Advocate General today also, that they try to portray as if the petitioner belongs to a privileged class and taking away something which belongs to others. They try to project the case in such a manner. But there is always a second story. It is other way around. The manner how they have tried to project is not correct. It is other way around. How? See, petitioner appeared class 12 in 2024. She passed last year. And then she did online coaching by staying in Ireland. She worked hard, she studied hard, and appeared in on passing. By virtue of her father's posting in the state, she has appeared, applied for a seat in the state. We are not claiming anything which we are not due, or whatever we are asking is on the basis of the provisions of law. Law permits this, so I have a right to claim, apply for it. So the petitioner applied. Now, this is the remuneration the petitioner is getting. Petitioner's father has submitted representation to 3 organs, Lordship. 1, to the Ministry, Health and Family Welfare. Another representation to the Chief Minister, Nagaland. Another representation to the Director of Technical Education. Till date, till this morning, none of the representation has been disposed of and considered also. So a person who has exhausted all the avenues are knocking the door of this honorable court for the ends of justice, seeking justice within the parameters. So coming to this honorable court cannot be treated like as if a person is going to a club. No. Only unfortunate people are before this honorable court. When they are victimized, when they are deprived their right, then only one can come to the court. It's not that easy as we think it to be to approach this honorable court. But having no other choice, I'm knocking the door of the temple of justice to get justice, Lordship. So it is not that the petitioner belong to a privileged class and then taking away the right of others. It is absolutely misleading, Lordship.
Okay.
Now, my learned friend, Additional Advocate General, as well as the learned Advocate General, was so found up projecting one thing, that is, the petitioner stood 1,13,803 in the All India ranking. The learned Advocate General start with that submission. By submitting that, what do you mean? What do you want to say? What do you want to support by saying that? If they are to go in that manner, I can also come and say that, look, in all the 8 subjects, I got A1 point. Will it be relevant? Other dear Lordship has categorically expressed that how that will be relevant.
Yes,
Correct.
the All India ranking is not relevant.
Yes. So what to do with the All India ranking? Just because she failed there, having failed there, she is coming and then trying to snatch away somebody's belongings. No, never. What type of submission is that? I would expect, at least from the learned Advocate General, that the substantial legal submission shall be made. How the notification of 9/9/2021 is testified in the eye of law. No submission was made on legal point. Only as if like a political speech. But one thing the learned advocates should be mindful, that emotional outbursts, or for that matter, giving a political like speech will not persuade the temple of justice, where the rule of law is supreme, and it will be the highest, it should be in the highest petitional logic. So while making all these irrelevant submissions, this are trying to mislead this honorable court, Lordship. Another very important point, Lordship, I am coming to the 4th point. Defense personnel has a separate quota, and then he has referred to para 3(1) of affidavit in opposition.
Yes.
I am furnishing a chart, Lordship. I will not make much submission on this. Ministry of Defense quota is primarily meant for the war wounded and battle casualties and widows. It has 9 categories, Lordship.
Okay.
And out of 9 categories, that is in receive priority for reservation preference for medical. Other courses are also there. But
You fall in
There-
8th, priority 8.
yes, 8, 3, 9. I fall on 9. There are
Not
9
9,
priority categories.
priority 8.
Priority 8, yes. Lordship is correct. There are 8 priorities, 9 priorities altogether. I fall under 8. Every year, up to priority 4, priority 3 and 4, it gets exhausted, the list. The quota which is allotted for the defense personnel are exhausted in category 3 and priority 4. And it never comes. We are in priority 8. Before us, ex-servicemen are also eligible and entitled.
Yes,
So, Lordship, that is very clear. What type of preference we are getting from the defense quota. But if I have some avenues, several else, that doesn't stop me, even to avail the other avenues as well if I'm eligible and entitled. Lordship. Not that he has that avenue, so he should always go there. And if he don't get there, he should not get anywhere. Can that be the principle of law in a welfare state? That submission is absolutely meaningless, baseless. Now, I will switch over to the next point, if Lordship is clear on that point.
yes, yes.
The next submission of the Learned Advocate General was that the defense personnel do not have a quota in the state quota. That is very, very important. Whether we have a quota or not, kindly come to 9/9/2021. If 42 seat central poll quota is only meant for the indigenous inhabitants of Nagaland, then what the notification of 9/9/2021 says, kindly come to page 142. I will just refer directly to that notification. This is the submission of Advocate General. I am replying on this submission, Lordship. The page 142, paragraph 1, eligibility criteria. There are 3 categories. Category 3, Lordship. Category 3, B and C. There are 2 Bs, so it can be treated as C.
No, there are not 2 Bs. Only 1 B is there. Second is only clarifying that what has been stated in 3B.
Yes, B. It is the document, it is the notification, and they have included. And
What do you want to say?
see the Government of India letter. Come to affidavit in opposition. Page 15. After this, I will come to the answer to your Lordship's query. Why, what I want to say, Lordship.
Okay. Page?
Page 15.
Yes.
This is the office, latest office memorandum issued by the Government of India on 28 July 2025.
Yes.
Here, Lordship will find in the next page. Page 17.
Yes.
1.5. Reservation.
Yes.
Mr. Lordship, Madam.
Yes.
Here, what is mentioned, Lordship has already seen, and kindly come to again, pre-page.
1.24.
3 and 4.
3 and 4.
Both the Government of India instructions and guidelines and the state notification of 9/9/2021 says about this. Lordship is same. And the submission of the Learned Advocate General was that the 42 seats which has been allotted by the center is only for the indigenous inhabitants of Nagaland. If that is to be accepted, then I'm answering to your lordship's query. Why they have shown these categories also, making me eligible. So the submission of the learned advocate general is contrary to what is mentioned in the notification of 9/9/2021 and the Government of India letter of 28/7/2025, where the eligibility criteria has been given, and I was found to be eligible and made eligible by put so as to include others. Because the submission of the learned advocate general was that it is only for the indigenous inhabitants of Nagaland. Therefore, his submission is contrary to what is mentioned in the two notifications. Therefore, in short, I must submit that the submission of the learned advocate general is baseless, without any basis. Why? It is contrary to the notification. He has no legs to stand. No basis.
Okay.
What you say and what is there on document and record is opposite. So it is appropriate to say baseless submission. Submission has no basis, no backing up law. Now, another important thing. The learned advocate general has made a mention about the status of the petitioner's father, that NCC headquarters is in Shillong and not in Nagaland. Therefore, the petitioner cannot claim Nagaland quota by virtue of hosting in Nagaland. And thereby he goes to say that the Nagaland is only a unit headquarters. Now, instead of making that up submission, I would like to refer to one document which I have already furnished with the other document. NCC group headquarters is in the state of Nagaland at Kohima, and it has 3 army units. In the second page, Lordship will find. Incidentally and surprisingly, Lordship, it is in the same, we are in the same colony. The High Court is located in the Old Ministry Hill. The NCC headquarters, group headquarters is also located in the Old Ministry Hill. And interestingly, it is about 300 to 400 meters away from the Chief Justice of the Chief Justice Bangalore. And the learned advocate general do not know that the NCC group headquarters is situated in Kohima. It is headed by a brigadier.
Which document says?
Second document, Lordship. Just referring a letter of letter written by on the brigadier on 24th May 2024. This is to show that the NCC headquarters, group headquarters is in Kohima, Home Minister's Hill, above Basin Office. Therefore, the submission of the learned advocate general is not correct. It is misconceived rather. It is not in Shillong. Group headquarters is in Kohima.
Where is that requirement
It
of?
has 3 army units. 1 Air Force unit.
No, that requirement of headquarters, where is, which notification says so?
Group headquarters is in Kohima.
No. The 9 September says regarding anything regarding headquarters.
Yes.
Where?
Lordship, Page 28. Lordship is at page 28. Paragraph 2. Last line, paragraph 2. Posted in and having their headquarters within the state will be eligible. So that is with regard to the posting. Because by referring to this, learned advocate general was trying to say that I am not eligible. But leaving all this, again, another very interesting thing.
Yes.
Kindly come to IA 144 of 2025. Page 7. Having
Page 7
page
of
7, paragraph, continuation of paragraph 7. Just above paragraph 8 in page 7 of IA 144 of 2025.
page.
Page 7,
Yes.
above paragraph 8,
Yes.
11 lines from the bottom and then fifth line from the top.
It is pertinent.
It is pertinent to mention herein that the name of the opposite party, number 1, petitioner, was not included in the selected candidate list as she failed to satisfy the eligibility criteria that is clauses in paragraph 1, category 3B, 2C, and 3E of the said notification to be selected for Nagaland State NEET UG 2025 for the academic session 2025-2026. Further, the name of the opposite party number 1 petitioner cannot be included in the selected candidate list until the notification dated 9/9/2021 is quashed and set aside. So this is the basis. By filing the application, the department has said this. So this is the contention of the state by filing this application. This is an affidavit. This, by order of this honorable court, this IA has been treated as affidavit in opposition of the state. So affidavit says this, the ground of rejection. And then the submission of the learned advocate general is somewhere else. Next point, Lordships, because I have to be hurrying. So as to keep our words.
Yes.
Next point, Lordship. The father of the petitioner not belong to all India service. That is also a point to be pondered.
No, you are claiming to be a central government employee, not
Yes.
all India, member of all India service.
Yes, and they have not disputed that, so let me not waste time on it. Because he was trying to say that all India service means IAS, IFS, and all this. Petitioner's father do not belong to all India service. That is what the learned advocate channel was trying to say. But the word employee, central government employee is mentioned.
Okay.
So that will be suffice, Lordship. I need not waste time. Now, another important point. Lordship has been repeatedly making query to the learned councils, but till now, they could not able to give a clear and direct answer whether it is yes or no. Same question was put to the learned advocate general in a clandestine manner. He has tried to avoid the direct answer, but tried to draw the attention of the court to some directions.
Concurrence.
Which is, yes, concurrence. Now, by saying this, concurrence of India, he was saying that nobody has objected, but Lordship may kindly take note of one thing. Forget about reply negative, positive, till date. Not even a single document has been placed by the state to show that this is the document where we have obtained the congruent suppression. Not even a piece of paper has been placed to show that they have taken the congruent suppression account. All replies were irrelevant replies. That means this very fact shows that they have not taken the concurrence of the government of India. And the learned Advocate General in categorical terms has admitted that, yes, we have accepted the government of India letter 9 December 1986. So the concurrence of the center has not been taken. No direct reply has been given. I would like to cite and compare with one Latin, the legal term, res ipsa liquidator. The legal principle of res ipsa liquidator will apply. There. The thing speaks by itself. Res ipsa liquidator, Lordship is well aware about this principle, that when there is nothing, no evidence, then what the document says, what the surrounding circumstances says, that will be relevant to examine. So the government of India guideline Lordship has seen, and what the government affidavit says, what he has submitted. Therefore, it's not that since nobody has come forward and claimed for this post, I should not also come. Nobody has questioned this. Can it be a certificate that if somebody has not questioned a document, I should also not question? If they remain stupid, can you expect me to remain stupid? No, I cannot. The moment I came to know about it, then I should claim for my right. The law permits me to do this.
Yes.
The next point, Lordship, the submission was the Haryana petitioner hails from Haryana, and petitioner do not have. Sorry. The petitioner is from Haryana, and in Haryana they have 13 medical colleges. Petitioner has various avenues, whereas the local people do not have such avenues. That too, in order to show that, look, they have many avenues, they have more privilege, whereas in comparing to this, we do not have the privilege and we are more deprived. Can you see the next chart, Lordship? I have published a chart. Comparison of the opportunities, options for indigenous applicants and options for the petitioners. In Haryana also we are not eligible. I'm not eligible because I'm not born and brought up in Haryana. So I'm not the domicile of that, so I cannot avail, even in Haryana. And then by looking at the chart, Lordship will find in serial number 4, just on the right hand side, Lordship will find under column 4, serial number 4, eligible but denied the rights. So this is, I'm talking about the 42 seats central poll. So without making any summation, this chart will speak for itself, Lordship.
Okay.
Next point, Lordship. The Learned Advocate General was referring to Mandal Commission report. For what purpose he was trying to show this, I fail to understand. Because Mandal Commission is a report of 1980. The entire report of Mandal Commission will be few truckloads. One piece of paper Learned Advocate General has tried to show to this honorable court. That was in 1980. Lordship is very well, Mandal Commission. And our 1986 notification is much after the Mandal Commission's report. And Government of India is not ignorant about the Mandal Commission report. They are well aware about the Mandal Commission report of 1980. Thereafter, this 9/12/1986 notification has been issued by the Government of India. And that time also the Mandal Commission report was already there.
Okay.
Whether Mandal Commission has approved and recommended for 100% reservation. Again, that is very, very vital to decide this case. Mandal Commission, to my mind, has never recommended for 100% reservation. Yes, as a welfare state, they have said so many welfare activities and stated equality, inequality, disparity. But then, what is the purpose of referring to Mandal commissions? I fail to understand. But as I have submitted, Lordship, it was of 1980, and after that 1986 notification has been issued. Thereafter, in 1992, Lordship is well aware, Indra Shawnee's case is also there. 2-3 cases of Indra Shawnee's case in 1992. And then thereafter again, Nagaraj case of 2006 is also there. And so many cases are there, including that Sandeep Jain, which I have referred to, your lordships. And then all the three cases which I have referred to are very, very relevant. And then in order to fortify that submission, again, a reference was made with regard to the 59 seats of Nagaland Legislative Assembly reservation out of 60. Only one is left for open. That is a very, very irrelevant submission in the sense that 59 seats has the congruence of the Parliament of India. It is approved by the Parliament, passed by the Parliament. Because he was trying to project that state of Nagaland, it is very peculiar, different from others, we should be treated differently, all these things. But it remains that this has the approval and congruence of the Parliament of India, the apex lawmaking authority in the country. And now, coming to our case, 9/12/1986 categorically says that the concurrence of the central government should be taken, whether for issuing 9/9/2021 for issuing the MBN order, whether at least a letter was written to the government of India, whether the concurrence of the government of India has been taken or not. It was never taken. I submit that it was never taken, and government has failed to show any paper on this. Therefore, Lordship, all the submissions are baseless, emotional and political like speeches will not persuade this honorable court, will not take away this temple of justice. Court cannot be influenced by irrelevant and misleading submissions, where the role of law should be supreme. Yes, I understand. There may be some difficulties for the government, but we cannot compromise with the rule of law of the land. So law is very clear that impure notification is required to be, it is arbitrary, illegal, discriminatory, and violative of Article 14. Therefore, it has to be set aside and quashed. And then petitioner should get deserving place as permitted under the law, Lordship. I have given in my prayer is mentioned in the prayer portion. Everything has been put and recorded in the pleadings, Lordship. So, if the rule of law is to be maintained, it is a fit case where this honorable court should mold the relief in accordance with law, Lordship. I conclude my
I may be allowed just a few minutes only to place on a judgment.
My lord,
this court.
enough is enough.
No,
They have given sufficient time to make submissions. What is this?
Lordship, he cannot stop me because it's my case. I'm also going to assist.
It is
the
my
court.
case.
I had already projected for which I'm going
Your
to
case.
rely on that
Observation.
Supreme Court judgment. And I'm going to make a little clarification to what my learned senior colleagues have said.
How much time will you take?
It's 5 minutes, that's
Lordship,
all. Beyond that.
petitioner will submit their case, respondent will counter that, and then the petitioner will reply that. That's enough everything.
This is the Supreme Court judgment based on the Gazette.
This is
which
the
you are
correct.
asking
Approaching the court.
I'm allowing you, but at 2,
at two, Lordship.
at 2.
Chief, I may be permitted to attend a meeting.
Oh, yes, yes.
Exempt. My
You're-
case will be exempted, but my failure will be
Miss, yes, he will be there.
there.
At 2, we'll continue.
Lordship. Much
For delivery of orders, item number 2.
No, item number 2 is a different one. Criminal petition, okay. For reasons mentioned in the judgment, the trial court is directed to conduct further inquiry to determine the age of the petitioner according to the provisions of Juvenile Justice Care and Protection of Children Act by subjecting the petitioner to an ossification test or other latest medical age determination test. This court also directs the trial court to complete the further inquiry within a month of date of receipt of a copy of this order. During the pendency of the said inquiry, the further proceeding of the special POCSO case number 55/19 shall remain suspended. After conclusion of the further inquiry, as directed by this court, the trial court shall proceeding accordingly, depending upon its finding in the further inquiry. This criminal petition is accordingly disposed of.
Highly obliged.
For delivery of order, item number 3.
For reasons mentioned in the order, the petitioner is allowed to go on bail of rupees 50,000 with 2 sureties of like amount with certain conditions mentioned in the order.
For motion, item number 1.
Yes,
Your Lordship, the case is listed. In this case, Lordship, case diary was called for.
case diary is
Second bail, this is the second bail application, Lordship, and last reject order is Lordship at
Mr. Sharma, have you received the case diary?
No, Lordship, it was sent back for updation, Lordship. It was listed before another court also, Lordship. The court has directed us to update the CD. Therefore, it has not been received, Lordship.
Today is 58 days, Lordship.
90 days offense, Lordship.
60 days.
What is your submission?
Last rejected on Lordship 24/7/2025, Lordship. Reject order is at page number 51. And all the offense, Lordship, the maximum punishment is 7.
No, Mr. Sharma,
Lordship.
what is your submission?
Lordship, a date may be fixed for the CD, Lordship, because the CD, after perusal of the case, the Lordship.
What is the maximum statutory period of detention? Under 487. Is it a 60 days offense or 90 days offense?
60 days, Lordship.
If
Prime accused Lordship was granted bail by your Lordship on 5/8/2025.
Who is the prime accused?
Abu Hanif Chaudhary, Lordship.
Where is his bail order?
Bail order, Lordship, I have not annexed, Lordship, as because it was filed earlier. This is the order, Lordship, I am having. A number 2.
What is the date of the order?
5/8/2020.
5/8. And bail application number?
2460.
Yes, Mr. Sharma, do you have anything to say?
Lordship, I will be praying for the CD, Lordship. Any day, Lordship.
Day after tomorrow?
Yes, Lordship, day after tomorrow.
Okay, heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. The prayer is allowed. Let this matter be listed on 14th of August 2025.
That lordship matter may be in 16, 17 is
Mr. Ahmed, you have to repeat what you said. We are not audible.
My lord, may I pray that lordship matter may be listed tomorrow, lordship, as because lordship 15, 16th and 17th are holidays, lordship. I would be completed 60 days on lordship 14th. So lordship, if matter is taken up tomorrow, lordship, then lordship,
Okay. Mr. Sharma, you inquire from the investigating officer, even telephonically.
lordship,
Otherwise, he will be completing his statutory period
on 14th.
instead of 14, 13. Tomorrow.
Partial moot, lordship.
Yes. Yes, Miss Shok.
Lordship, today the additional, the Advocate General would have appeared, but since he has some health problem, he could not appear. Yes, so I'm taking his place. Lordship, with regard to some clarification, what my learned friend has been saying is that the petitioner had been representing to the department, but there is no response. That's what he has stated. If we look at the documents, the petitioner never represented to the department. It is the petitioner's father who represented to the department. So the petitioner is a major by age.
No.
Yes.
Does it make any difference?
Yes, it makes a difference. Only the person who is aggrieved, he can only represent it to the department, not through somebody else, because she is major by age. That is number one.
Okay.
Yes. And the second one, the petitioner, she is from the general category, Lordship. So if this 42 Central Pool seat, which is specially for the state of Nagaland to uplift the medical professional, Lordship, if we allowed, then it will amount to opening the gate, overflowing the general candidates, Your Lordship. So the very benefit of the scheme to the state of Nagaland would be defeated. Then Lordship, I may be allowed to place one judgment. It's regarding with the publication in the official gazette. That is, Lordship, may kindly come to para 8. I will rely on para 8 and 11. 8. It could not be denied that GO number such and such dated 15/4/1997 was published in the official gazette on such and such. It is settled law that once publication in the official gazette takes place, it is deemed to be known to all. Ignorance of law can be no excuse. Once the GO was published, from the date it was published, it becomes effective. As it became effective from that day, the tax was leviable at the rate of 4%. If some assessing officer, due to their own ignorance or laxity, accepted returns at the rate of 2%, it did not permit the High Court to ignore the law and continue such laxity to prevail. It must be remembered that the assessing officer who had assessed wrongly could always reopen the assessment. 11. It was also submitted that since there was a lot of confusion and that number of parties, including assessing officers, were not clear as to what was the rate of tax, this court should not interfere with the judgment of the High Court, which has been passed on equitable basis. We see no substance in this submission. If the law is clear, then it must be given effect to. Merely because the parties were unaware of the law does not mean that court can ignore the law and provide to the contrary. Lordship. So, Lordship, my prayer is that the petitioner has not made out a case. If the petitioner is going to, if this honorable court is going to interfere, then one seat from the indigenous inhabitant of Nagaland will lose the seat. So it will amount to passing an order without hearing the other party, Lordship. That's all. Much obliged.
Heard Mr. C.T. Zamir, learned senior counsel, assisted by Mr. I. Im Chen, learned counsel for the petitioner. Also heard yes. Hearing concluded. Let this matter be listed for delivery of judgment on 14/8/2025, day after tomorrow, Judge.
Much obliged.
For admission, item number 30.
No, keep these documents in the document file. Yeah. Yes, who is from the health department, that person? The officer. Give it back. Mr. Imchen, you take back this seal envelope. This may not be required. Yes.
This, my lord. My lord will be tired, but my lord, I won't take too long. It's just a simple matter for my lord's consideration. My lord, the case is primarily about regularization of work charge employees.
Just a minute. Albert, keep this one also. Yes.
My lord, my case is primarily based on the office memorandum 2004 for regularization of work charge employees.
Regularization.
Yes, my lord is well aware of that office memorandum as well. Now, the facts of the case is that, my lord, the petitioner's husband was appointed as work charge handyman in the year 1983, 2nd of July 1983, and he served as a work charge employee in that capacity for 28 years and 3 months until 28 years and 3 months until his unfortunate demise in the year 2011. 22nd of August 2011, 22/08/2011.
When your husband was appointed?
2/5/1983. 2/5/1983 as a work charge handyman in a scale of pay, my lord.
Okay.
Scale of pay was granted at the time of appointment, my lord. And he died in the year 2011. Now, the petitioner pursued for regularization of his services for pensionary benefits, which was denied, my lord, by the department. Now, the factual situation as of today is that on 2 occasions, the regularization of the petitioner's husband was approved by the government. But because of one case which the apex court has passed in the year 2017, Nishibi Achumi. On the basis of that, or 2022, my lord, 2022, in civil appeal number 4223.
What is the citation? What is that case? Do you have a copy?
I have a copy, man. In fact, state respondents
annexed it in their affidavit in opposition.
Oh, it is there. Okay.
So on the basis of this, the department sent the petitioner's case for reconsideration to the government. Now the government, after thorough consideration, after the judgment was passed, reiterated their first approval and said that a post should be identified to accommodate the petitioner's husband for pensionary benefits. But till date, nothing was done. So the petitioner sent a representation to consider it on the basis of the approval of the state government. But that was not done. So the petitioner was forced to approach this honorable court. Now, if I may, just there are not much.
Now petitioner's husband is no more.
No, he demised in 2011.
So a post has to be identified now.
Yes, Lordship, at the point when
He
approval was
died.
given, 2022, the year 2022.
Uh,
If I may take my lord to the annexures one by one.
2022,
Yes.
but your husband died in the year 2011.
That is a. Yes.
How that will be accommodated? Suppose a post is available, the regularization will be posthumous regularization from the date of when he was alive.
In other similar cases, 1 day prior to the
His death.
deceased, that was done.
So at that time, a post must exist. Some post must exist.
Yes, I will show that from the annex. I filed subsequent RTIs to identify, to assist this court that this was the position at that point of time. Now the question for this honorable court to consider is whether at that point of time, when the petitioner husband was alive, that is in 2011, whether the petitioner was in line or eligible to be considered for regularization on the basis of the office memorandum. The office memorandum says that as per the seniority, a post has to be created to accommodate, to regularize the services of the employees. Now,
You are praying for regularization for the purpose of getting pension.
yes,
For the purpose of getting pension.
yes, I have mentioned.
Only pension.
Yes, I've mentioned. It's only for pension benefits. But
Okay.
in right after the representation, the first after the demise in annexure 24, annexure E, page 24, I've annexed one representation.
Yes.
So when the petitioner approached before his demise, when the petitioner approached the department with regard to regularization of his services, he was informed that since one factual position is that, my lord, he was appointed as handyman. But in the year 2007, he was again promoted to, in the year 2007, he was promoted to driver, or 2004, no, to driver, work charge driver.
Yes.
But in the year 2007, he was again demoted to handyman because of his inability to learn how to drive. That is the factual position.
No.
When the petitioner husband was alive. Now, when he was pursuing for regularization, the department was of the opinion that he has to be regularized. In order for him to be regularized, he has to pray to the department for reinstatement of his service, not as handyman, but as a driver. So accordingly, annexure E was submitted by the petitioner to the department. So pray for reinstate of vehicle driver on humanitarian ground for family pension benefit. And this representation was right after the petitioner husband's demise. The date, effective date is 27/9/2011. 27/9/2011.
Yes.
May I read, my lord?
Yes.
With due respect, the subject cited above, that, sir, my husband, late Dushimran, was promoted to work charge vehicle driver on 23/01/2004, but he was demoted to handyman on 1/03/07. So I therefore request you to kindly reinstate to vehicle driver on humanitarian ground for my family pension benefit, for which act of your kindness I shall be highly obliged to you, sir. This is the first representation made by the petitioner, not the petitioner husband, but the petitioner after the demise of the petitioner husband. Now, after that, the next annexure, my lord, page number 25. So after this, after the representation 27/9/2011, the department informed the petitioner that his case was under consideration, her case was under consideration, and she waited for it. And since there was no positive response, she made a representation dated 23/6/2022 to the Engineer-in-Chief Department of Power.
Yes.
So this representation here, like my lord has asked rightly, here also the petitioner asked for benefit of granting regularization on retirement for the welfare of the family. We can infer that it was only for pensionary benefits that the petitioner was asking. So the next annexure, page 26G, is the letter forwarded by the Engineer-in-Chief to the government, Principal Secretary to the Government of Nagaland. Request for posthumous regularization of work charge service in respect of led Dushimran work charge handyman for family pension benefit, my lord. If I may read, my lord.
No, it's okay.
And the next, after this, the government's, this was the government's reply, my lord. This is the first approval. Annexure H, page 27, my lord.
Yes, please read.
Posthumous regularization of work charge service in respect of late Dushimran. In inviting a reference to a letter number such and such dated 29/06/2022, and on the subject cited above, I am directed to quote the observation of BNR Department for necessary action, my lord. The matter has been examined and the department is requested to identify the vacant post against which the posthumous regularization of late Dushimran work charge handyman can be facilitated, and thereafter to resubmit the proposal for further necessary action. This is the first approval communication by the Undersecretary of the Government of Nagaland. Now, my lord, this is the next annexure I is the point of contention in this present writ petition, my lord.
Yes.
And for that reason, I have impugned this letter communication. Now, at the outset, I've mentioned about the case of Nishibin. So here, the understanding and the intention of the department will be manifested in this letter, my lord. If I may read, my lord.
Yes.
Posthumous regularization of work charge service in respect of late Dushimran. Inviting a reference to the above, I have the honor to state that though this office has forwarded a request letter by Srimati Anungla for posthumous regularization of her deceased husband, white letter number such and such, dated 29/06/2022, it is requested to consider the observation of the BNR department before taking further necessary action in respect of late Dushimran work charge handyman. In this connection, here the operative portion, my lord. In this connection, in a similar case, the request for posthumous regularization in respect of late Nishibi Achumi was quashed and set aside by the Honorable Gauhati High Court Kohima bench, and consequently the original writ petition filed by respondent wife was dismissed by the Honorable Supreme Court of India dated 11/7/2022. This is the date of the judgment, my lord. Therefore, in the light of the above, it is requested that the government may reconsider the observation of the BNR in respect of late Dushimran work charge handyman so as to avoid litigation from the previous party. The language, my lord. Requested the government may consider the observation. Now, after this impugned letter was forwarded to the government by the Engineer-in-Chief of the Department of Power by letter dated 31st October 2022, Annexure J, my lord. This was the government's reply, my lord, if I may read.
Yes.
Subject posthumous regularization of work charge service in respect of late Dushman. Inviting a reference to your letter number such and such, 23rd August 2022, on the subject cited above, I am directed to reiterate the observation of BNR department and request you to identify any vacant post, group C and D, against which the posthumous regularization of late Dushman work charge sentiment can be facilitated. My lord, I have made a specific prayer in my petition that this honorable court may direct the state to consider the case of the petitioner in line with this subsequent observation and this, and my lord may kindly note 31st October 2022. This was after the case of Nishibi was delivered, my lord. Now,
What was held in Nishivi?
yes, after that, my lord, just before I come to that, after that, I've also made another presentation before approaching this honorable court. Page 30, Annex 8K. Now, if my lord. My lord, I can take you to the judgment in Nishibi.
Yes.
It is a short judgment, in fact, my lord, and my lord may kindly appreciate the fact that this judgment was passed ex parte without the respondent party, that is the petitioner in the original writ petition. Now, may I read, my lord?
What was the relevant paragraph?
4.1 is the observation. 4.1. Paragraph number 4.1.
Yes, please read.
It is required, may I read, my lord?
Yes.
It is required to be noted that the deceased employee died in the year 2005. During his lifetime, he never claimed any regularization. That the respondent herein, original writ petition, wife of the deceased employee, claimed the regularization after a period of 12 years from the death of the deceased employee. At the time of the death of the deceased employee, he was not entitled to regularization as he was much below in the list of the work charge employees whose services were to be regularized. Under the regularization policy, the services of the work charge employee were required to be regularized as per the seniority and as and when the vacancy arises. The services of the other work charge employees can employees even who were senior to the deceased employees were regularized in the year 2009 after the death of the deceased employee. Despite the above, the High Court has directed the state to regularize the services of the deceased employee 1 day prior to his death, which otherwise his services were not required to be regularized as his turn had not come and he was much below in the seniority list. Considering the aforesaid facts and circumstances, the impugned judgment and order passed by the High Court is unsustainable and the same deserves to be quashed and set aside. In view of the above and for the reasons stated above, present appeal is allowed. The impugned judgment and order passed by the dividing bench of the High Court as well as the learned single judge is hereby quashed and set aside. Consequently, the original writ petition filed by the respondent wife herein stands dismissed. However, in the facts and circumstances of the case, there shall be no order as to post. Now, if I may.
Sorry, what was the reasoning? That
Yes,
you were not, that Nishivi was not
Yes.
entitled.
Yes, there were two things. One was, the first point was laches on the part of the wife, deceased wife. She never pursued the matter. Only after a period of 12 years, she woke up and pursued the matter. That was one consideration. Second was, and which is the most important, my lord, Nishibi Achubi was way below the seniority list. Way below. And
Had he
he
been
was
al-
not in the zone for consideration.
Had he been alive, he would not have.
Yes, my lord.
Had he been alive,
Yes.
Nishivi.
Yes, my lord. He
un-
would not have even
regularized.
because
That was the logic.
yes, his seniority was way below. So even otherwise, at that point of time, when his case could have been considered, he was not eligible. That was a two consideration. Now, in the present case, my lord, it is an admitted fact, even from the affidavit opposition filed by the state respondents, that the petitioner husband was at serial number 1 all along. And
No, why are you impugning this letter? 23rd August, which directed for reconsideration.
just to the extent that, my lord, to the extent that there are.
Because even after reconsideration,
Yes, my
earlier
lord.
decision was reiterated.
Yes, after that subsequently it was reiterated. Yes, just for abundant caution, we impugned that letter because the understanding, the reason behind rejecting my case was on the basis of a misinterpretation of a judgment. There was a misplaced understanding, and on the basis of that, my
No.
case was.
After it was reiterated, you again filed a representation.
Yes.
What
Yes.
happened thereafter?
Nothing.
Then you approached this court.
Yes. After that, after waiting for some time, we approached this honorable court.
Yes.
Now, that is the factual position, my lord. So I just want to sum up. This the point of determination for this honorable court from the petitioner side is that the petitioner was approved, the petitioner's case was approved by the department, by the government, and after which the department communicated to the government for reconsideration, and after that, the government, after reconsideration, reiterated their first approval, even to the extent the consideration made by the BNR department. So the department here, what we can conclude here is that the department conveniently ignored the approval letter of the government just to deny the petitioner her pensionary benefits. The second, my lord, the refusal of the petitioner's case on the basis of the case of Nishibe Achumi is misplaced for the reasons that are on it.
No. How you came to know that your case
Yes, my lord.
was refused on the basis of this case?
Because
the reconsideration was requested
yes,
on the basis of the Nishivi's case.
yes.
But after that,
the yes,
earlier decision was reiterated.
But after that, after the reiteration, when the petitioner approached the department before she submitted the representation, that the department was of the clear opinion that after Nishibi there cannot be any posthumous representation. But that is a misplaced understanding of Nishibi Achumi's case and the principles of law. Now, my argument to that effect is that only on two grounds. The case was decided strictly on the basis of the factual position of that particular case, my lord. And my lord, in your wisdom, very well knows that judgment cannot be binding unless and until the point of consideration or the issue of regarding one point has been conclusively decided. And here in Ishibi, the case of posthumous, the matter of posthumous regularization was never considered and never decided. The Nishibi Achumi did not, in the judgment, did not say that henceforth in the state of Nagaland there cannot be any posthumous regularization. No, that was not the case. The only point that was decided in Nishibi was on the factual position on two grounds.
No. Nishivi was decided on the basis that the petitioner's husband was not found to be entitled on the date of his death for regularization.
Yes.
Your case appears to be similar.
No, my lord, there are stark differences in my case. Mine, if I may take my lord to the affidavit in opposition filed by the state responsible.
Yes.
They have annexed one seniority list, my lord. Page number 10, annexure 3.
Yes.
Tentative seniority list of work charge handyman as on 1/6/2010. Here, serial number 1, Shri Tushimur. This is the petitioner's husband. He is at serial number 1. And my lord may kindly appreciate that serial number 2, 3, 4, 5, 6 were regularized, who were much below the petitioner's husband.
When they were regularized? After the death of the...
Yes, I have annexed in my petition, my lord. Some of the,
No, what stand the state respondent have taken in their affidavit in opposition?
there are only two grounds in the state's contention. She can have her time, but then just my observation. Now, the only stand in the affidavit in opposition is that number one, Neshibi Achumi, on the basis of Neshibi Achumi, posthumous regularization cannot be granted.
Okay.
Number two, their contention is that had the petitioner husband been alive, he could have been regularized since he was the senior most in the list of seniority list. That is the two grounds. And my lord, the third ground is that there was no post creation of handyman at that point of time. And only in the year 2012, posts were created, 381 posts were created to accommodate work charge handyman.
Yes.
Now to that, I want to, with regard to Nishibe Achumi, my lord will know better, and I've extensively submitted that it is a misplaced understanding. But with regard to the post creation, if my lord, if I can take my lord to just one annexure and page 40 of my repetition, my lord. I've annexed the Nagaland Work Charge and Casual Employees Regulation Act of 2001. On the basis of this act, my lord, 2004 Office Memorandum 2004, the policy of regularization was issued, my lord. So I want to take my lord to Rule 12. May I read, my lord? Page number 44. Rule 12.
Yes.
Scheme for absorption of service, my lord, the language. Scheme for absorption of service. The state government may throw up a scheme for absorption of service of work charge employees into regular government service. So on the strength of Rule 12, the Office Memorandum 2004 was formulated. For my satisfaction, my lord, if I may take my lord to page 47, Office Memorandum.
Yes.
Clause 4. Page number 47.
Yes. Yes.
If I may read the first paragraph, my lord.
Yes.
There are large numbers of work charge employees in various departments. Many of these employees have been serving continuously for many years. They have been representing to the government for regularization of their service. Some departments have been regularizing the service of work charge employees from time to time against available vacancies. However, no transparent and rational policy and criteria is discernible in the process of regularization of service of work charge employees. Therefore, in order to examine the issue of regularization of work charge employees in various departments, the state government set up a committee under the chairmanship of Shri such and such. And on the basis of the recommendation of the Committee for Regularization of Work Charge Employees in the state, the government hereby adopts the following policy and scheme or regularization of the service of work charge employees serving under various departments of the state. One of the relevant clause will be clause 4. Work charge employees will have the right, my lord, the languages will have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. This means that a senior most work charge employee in the relevant category will be regularized subject to his or her fitness for a vacant post. Now, the first line, the language, my lord, work charge employees will have the right to be considered for regularization, which was denied during his lifetime and after his demise, unfortunate demise also, until today. His right has been denied, and that denial has even perpetuated to the wife and to the children, my lord. So now,
The prayer for
yes,
upgrading or from handyman to driver,
yes,
who made that prayer after the death of the There was a communication
Yes,
letter.
the communication was right after the death. But prior to that, the petitioner and the petitioner husband were pursuing the matter for regularization. Since in their own department, some of the employees who were quite junior to them were already regularized.
So you filed any application? Your husband filed any application?
Yes, I have instruction that they have filed a representation.
Where is that?
Representation, but after the demise, they could not trace out the documents.
You have
So for
made-
that reason, we have not annexed, my lord.
Okay.
To that extent, I'm admitting, my lord, it is an honest admission, my lord. There's no on record and before this court and not with us. There's no documents as such. So now the only, my lord has already understood the factual position, my legal understanding of the situation. The only thing that need to be considered in order to come to closure, my lord, even the petitioner deserves a closure at this point now. She has been told by the department again and again that your case is under consideration, your case is under consideration, and rightly so, 2011, and today we are in 2025. Her case has never been positively considered, though of course the government has approved and reiterated their approval, but the department still insists that her case cannot be considered on the basis of Nishibi. Now, in the case of Nishibi, there were only 2 points.
Okay, no repetition.
Yes, seniority, but the petitioner's husband, the only question is whether at that point of time, before his demise, whether he was eligible to be considered on the basis of seniority. And rightly, the petitioner husband was the senior most.
Senior most as an handyman.
Handyman. But my lord, since my lord has asked that question, I want to point out one, I've raised that question. I've raised the writ of contagion in my affidavit in opposition. Affidavit in reply, my lord. If my lord can refer to my affidavit in reply, paragraph number 3.
Yes.
Now, my lord, in the affidavit in opposition, page number 10 of the government, they have annexed one seniority list, which I pointed out to my lord. The petitioner's husband is at serial number 1. But when we filed, before coming before this court, before approaching this court, we filed an RTI, dated RTI, asking for the seniority list. Page number 8 of my affidavit in reply, annexure A1. By reply dated 6th May 2024, they have furnished the compilation of the seniority list. Now, page number 9 of the affidavit in reply. In this is the tentative seniority list of road church handyman as on 1/6/2010. Here, apparently, in this annexure, in this document which was furnished through RDI, the petitioner husband is not in the list. This is a handyman. This is the seniority list of handyman. Now the next page.
Know what it indicates?
Yes, my lord.
Why are you showing this? What it indicates?
I'm showing this because I want to make a comparison to the list that was furnished to me through RTI, where the petitioner husband was never mentioned, and in the affidavit in opposition, in the same document, they have inserted my name as serial number 1. So there, for reasons best known, at this stage, I cannot authenticate what is the reason why they did in the document that was furnished to me, they did not show the petitioner's husband name. But in their affidavit in opposition, after we have filed this petition, they have conveniently inserted my name as number 1. But my lord, I leave it to your wisdom.
No, by showing this discrepancy.
Yes.
What do you want to submit?
Yes, what I want to submit.
Discrepancy is apparent.
Yes.
But what do you want to submit? How it helps you?
Yes, it is my submission that all along, the department, in order to deny the petitioner husband and the petitioner after his demise, the petitioner offer rightful pensioner benefits as rightly said. It is a right in the office memorandum. It is the right for the employees to claim for regularization. Now, to deny that, they have conveniently, over and over again, they have conveniently omitted my name, so that when the process of regularization happens time and time again, his case will never be considered. So this is what I can infer from the action of the State Department. Now, another point, my lord. Page number 10. This is the seniority list of driver. If his name is not in the handyman list of seniority list of the handyman, at least he should have been in the list of driver as on 1/6/2010. But his name did not figure in the list of driver as well, my lord. But only after we filed the rate petition, after we have received the affidavit of opposition, we were made aware of the seniority list wherein the petitioner husband is shown at serial number 1 as the senior most.
Okay.
But be that as it may, looking at the date of appointment of all the persons in the seniority list, the petitioner husband would have been the senior most.
Okay, okay. Yes.
That is my
Yes, yes.
that is my case. Just to support my contention, my lord, I will place some citation, my lord.
What citation?
I have just a few, my lord, just to help to make my point across, my lord. First is 2008 to SCC 533.
What it says?
Just paragraph number 11 and 12. my lord.
No, what it says. First you have to tell, then I will allow you to read.
Yes, my lord, it says that a decision is a precedent in its own facts,
Okay, okay,
and each case presents its own features.
okay. That I agree.
Yes.
You need not to read.
My lord, the second, I won't read, I'll just point out the paragraph. 2004 8 SCC 579. Now the ratio here is that, my lord, paragraph number 11, my lord.
What it says?
Circumstantial flexibility. One additional or different fact may make a world of difference between conclusion in two cases. Disposal of cases by blindly placing reliance on a decision is not proper. That is the ratio, my lord.
Okay.
The next is 2011 9 SCC, page number 354. 2011 9 SCC 354. Paragraph number 42, 43, and 44, my lord.
What it says?
It says that a point in respect of which no argument was advanced and no citation of authority was made is not binding and would not be followed. So in Nishiri, in respect to Nishiri, the question of posthumous regularization in itself was never a point of contention and no arguments were advanced on that point. So that is, and the next is 2002 3 SCC, 2002 3 SCC 533, paragraph number 9.
What it says?
It says on the court should not place reliance on decisions without discussing as to how the factual situation fits in the factual situation on which the reliance is based upon.
Okay.
That is on with regard to Nishiri. Now, the last one on the question of the misrepresentation made by the State Department in their annexures in the affidavit, my lord. I just want to place one small reliance on one case. 1995 3 SCC 757.
What it says?
It says that filing of false affidavits in judicial proceedings in any court of law amounts to criminal contempt, and any person doing so is liable to be severely dealt with. I leave it to the wisdom of this honorable court. For me,
Now you are saying that they have annexed a false document.
Yes, for me.
Your name
my lord-
ought not to have been there.
Yes,
That your submission?
my lord, I will not press upon this to the extent that since I'm also asking for a compassionate consideration of this honorable board and also to the said respondents, just for pensionary benefits, I will leave it to the wisdom of this honorable board. Now, this court on 2 occasions have passed judgments on some questions with regard to posthumous regularization. One is 2017 2 GLT, 2017 2 GLT, page number 370.
What it says? Yes, what it says.
Paragraph number 12, my lord, it says that this is a case where family pension was the subject matter. Now, the respondents in this case, the respondents were directed to regularize the service of the petitioner's husband 1 day before he expired for the purpose of giving pensionary benefits, including family pension to his wife and children. So I just want to show this.
This you are relying to show that this can be done.
Yes.
Only to.
Only to that extent.
Okay.
And the last one, the question of how, this honorable court if this honorable court is of the opinion that it should be granted, this honorable court will also be in a position where how to go about in granting pensionary benefits, the areas involved. So for that, I want to make a reliance on one judgment to assist this honorable court to come to a conclusion.
Yes.
So here, the point is, this court is left with no choice but to direct the respondents to regularize the service of the petitioner's husband posthumously, so that the petitioner and her children can enjoy the pension and pensionary benefits within a period of 3 months. My lord, if I may take my lord to the second last paragraph, my lord.
Yes.
No, my lord, this case, with regard to the areas and pensionary benefits, it was the previous 37 GLD, and with regard to this one, discrimination, on the point of discrimination. That the petitioner, while many others were regularized at that point of time, as well as after the demise of right after the demise of the petitioner's husband, he could have been regularized during his lifetime, and even there were chances for the department for the state respondents to regularize the service of the petitioner for pensionary benefits. But that was not done. So I'm citing this case on the question of discrimination, which is the action of the state respondents, which is in effect violated for Article 14 as well as Article 21 of the Constitution. So that's
Yes, Miss Amy.
Your Lordship, on the issue of the seniority list, no illegality was committed by the department. The seniority list received by the petitioner through RTI, that was the drafted tentative seniority list, Your Lordship. And the one I submitted in my affidavit, that is a certified true copy, because when you compare the two seniority lists, the one submitted by the petitioner, it has only the signature of the chief engineer. But in my affidavit, the one that I submitted, it contains both the signature of the chief engineer as well as the engineer in chief. So, Your Lordship, there is no discrepancy here in the seniority list. Now, Your Lordship, coming to my submissions, when the petitioner was alive, there was no vacancy, there was no regular post of handyman. It was only after the petitioner had demised that in the year 2012, by order dated 10/1/2012, the regular post of handyman was created, Your Lordship. And subsequently in the year 2012, four employees junior to the petitioner's husband, they were regularized. because at that point of time, the petitioner's husband had already died, Your Lordship. Moreover, Your Lordship, the government has no policy with regard to granting regularization for posthumously, Your Lordship. Now, Your Lordship, Nishevi's case, the petitioner's case is covered by by Nishevi's case. Here, Your Lordship, in Nishevi's case, 3 observations were made by the Supreme Court. The first was that during the petitioner's lifetime, he never claimed for any regularization. Similar in this case also, Your Lordship, the deceased, he never claimed for any regularization during his lifetime. No records are available in the department also, Your Lordship. And the representations that the petitioner has submitted, that is with regard to reinstatement to the post of driver. And the other 2 representations were made in 2022 and 2024. All these 3 representations were made after the demise of the petitioner's husband, Your Lordship. Now, the second observation made by in Nishevi's case was the claim for regularization was made after a period of 12 years from the date of the demise by the wife of the deceased, Your Lordship. Similarly, in this case also, after the demise of the petitioner's husband, the wife claimed for regularization after a gap of 11 years, Your Lordship. 11 years, 6 months. And the third one, in Nishevi's case, he was not entitled to regularization because of his seniority. He was way below the seniority. But in this case, though he was the senior most, yet there was no vacancy, Your Lordship. There was no vacancy, and the regularization policy that was applicable, that is the 2004 policy, it clearly states that the senior most employee will be regularized only if there is vacancy. But in this case, there is no vacancy, Your Lordship. Moreover, Your Lordship, I would like to rely on 2 judgments passed by this Honorable Court, Your Lordship. These are all with regard to posthumous regularization. In WPC 102 of 2009, I have highlighted the relevant portion, Your Lordship. Here, the court observed that, if I may be allowed to read,
Yes.
page number 4, paragraph 3, the highlighted portion. If the husband of the petitioner was not entitled to regularization during his lifetime, the question of issuance of a direction to the authorities for granting of regularization posthumously does not arise, Your Lordship. This was the observation made by the court, and the court had dismissed this writ petition. And the second one is WPC number 332 of 2023 and WPC 331 of 2023. The relevant portion is at page number 20, the last. This is the observation of the court. This court is of the view that the 2 petitions are covered by the judgment of the Honorable Supreme Court in Nishevi's case, inasmuch as the deceased employee had never claimed for regularization during their lifetime. And the second point is that is with regard to WPC 331. There was no vacancy in the category of plumber helper as far as the deceased employee was concerned in WPC 331. Therefore, the writ petition being devoid of merit stands dismissed, Your Lordship. In all these cases, the petitioners, the deceased person was on scale pay and a work charge employee, Your Lordship. So they were on similar footing, Your Lordship.
Okay.
So that will be all, Your Lordship, my submission.
Albert, any matter is there? 2 more letters.
Hello, if I may just submit one cabinet memorandum with regard to one similar case of posthumous regularization. I've cited GLP.
What do you want to show by placing this?
That since the state government is there contention is that there's no provision with regard to posthumous regularization. That is their contention, in essence. But the concept of posthumous regularization cannot be anticipated and cannot be inserted into the office memorandum or neither in the statute. Because posthumous regularization, it is my understanding that it is a judicial interpretation based on existing conditions. When there is provision for regularization, then it holds no ground that since there's no provision specifically mentioned in the office memorandum that posthumous regularization cannot be done. Whereas the action shows that by placing this I'm trying to show that the state government has been on the facts and circumstances of each case, they have been making decisions whether somebody is eligible for regularization for pensioner benefits or
No,
not.
this cabinet memorandum is a document which is placed before cabinet for taking a decision.
Yes.
This was prepared because there was a judicial direction.
Yes, I cited this with regard to one of the citation that I placed. So I'm just showing that the point that they are saying that posthumous regularization is not there in the provision, so it cannot be granted as at the suite. That is a misplaced argument. Just to that extent.
Okay.
Your Lordship, with regard to the correspondence made between the interdepartmental correspondence that the petitioner is relying on, I have mentioned in my affidavit at paragraph 9 that interdepartmental correspondence does not give any legal right to the petitioner to claim for posthumous regularization, Your Lordship. So this may also be recorded by submission.
Okay. Heard Mr. N. Toshi Longkumar, learned counsel for the petitioner. I am reserving the judgment. Also heard Ms. A. Aimi, learned government counsel, appearing first.
Respondent 1 to 4.
Respondent number 1 to 4. Hearing concluded, judgment is reserved.
For admission, item number 31.
These books. Yes. And the citation should be given in a separate file. Which item you have called?
May I please, Your Lordship? Lordship, this incident matter, this is with regard to seeking regularization, Lordship. However, Lordship, the state respondent, the learned additional AG, sir, he was appearing, but I think he's no more in the court.
So what?
And I'm not sure whether he has entrusted any of his junior or any colleague.
But state is represented by Mr. Sanktam. Yes, when nobody is there for the state, any officer of the state present in the court. What is your submission now? We have to adjourn the matter.
In fact, Lordship, here there is some urgency is that here the interim prayer is yet to be heard. In fact, Lordship, yesterday it was listed yesterday. However,
What is the matter?
Lordship, this is regarding the regularization, Lordship. Here the
What interim you are seeking?
to state the administrative approval for recruitment of the vacancies, Lordship. So there's a administrative.
Some person have been.
Not yet. They are yet to advertise the post, Lordship. However, there's an administrative approval to pursue with the recruitment process, Lordship. So, and here their petitioners are already serving, Lordship. however, on contract basis. So they are seeking for reservation of 3 posts till the disposal of this case. That is the interim prayer, Lordship.
No, we'll finally hear the matter.
Lordship, yes, Lordship, if, I'm not pressing on interim if they are ready to take up the matter today, Lordship.
Send the information.
Is there?
He could be there, man. I'll send my.
What is your case? You can.
Lordship, here the petitioner 2, 3, and 4, they are serving as a driver on the contract basis under the Department of Directorate of Printing and Stationery, Nagaland, Lordship. Lordship, they have been the petitioner number 1, Lordship. He has petitioner number 1 is the president of the association, Lordship. They are appearing on behalf of they are also proceeding the matter on behalf of the petitioner number 2, 3, and 4, Lordship. So the petitioner number 2 and 3 have been serving for more than 25 years, Lordship. And the petitioner number 4 has been serving for almost 14 years now, Lordship. So during this, Lordship.
Who is the petitioner here?
Petitioner number 1 is the president of the association, Lordship. Lordship, here the petitioner number 2, 3, they being the senior most, they are pursuing the matter on behalf of them also. So on their behalf, they gave a representation also, Lordship. The representation I have annexed in my petition also, which is at annexion 9, page 30, Lordship. So, Lordship, the brief fact is that, Lordship, while after submitting this representation, Lordship, the petitioner had they came across this
Petitioner number 1 is the association.
Lordship, yes, Lordship, appearing on behalf of the association, he is the president, Lordship. They are pursuing the matter on behalf of 4 and on behalf of this petitioner 2, 3, and 4, Lordship. So the imprint of administrative approval, Lordship, it's at page 41, annexure 16, Lordship. So after they gave the representation, they came across this administrative approval stating that giving the direction to advertise the 6 post, Lordship. The 6 vacancies that has arisen in the department.
Whether the respondents have filed affidavit in.
Yes, Lordship. In fact, in the representation, Lordship, in the affidavit of opposition, Lordship, there's nothing but just the contention that while our representation was pending, this writ petition has been filed. That's the only contention that they have made in their opposition, Lordship. Nothing more than that, Lordship. However, regarding the contention, Lordship, we gave
Mr. Zimomi, who will be appearing?
Lordship, in this case, additional LG in team song is appearing for the.
He's not there.
Lordship is on the way.
He's coming back from.
From the channel, from his way.
It is in the premises.
Lordship.
Okay.
He's with me.
Okay.
I continue, Lordship.
You can give me the gist because submissions you have to make in his presence. But so that I understand and we can utilize the time.
So, Lordship, the fact is that the petitioner 2, 3, and 4, they are initially they were appointed on contingency. Petition number 1 and 2, and again they were appointed on contract basis.
No, 1 cannot be appointed. 1 is association.
Yes, Lordship. I mean the respondent petitioner number 2, 3, Lordship.
4. You have to be very clear about.
Lordship. So 2, 3, they were initially appointed on contingency basis, and again they were appointed on contract basis. So and they have been serving for 24 years now. Now it's 25 years running, Lordship. So Lordship, by this they sought for regularization, Lordship. However, nothing was in meantime.
So, can we hear for final disposal?
Worship, I have a suggestion to us. Since we have filed the affidavit, so this matter will be fixed on Monday or Tuesday next for final.
Final hearing?
Yes.
Yes, that can be done.
That I have no issue if it's to be taken on.
Instead of their pressing for
Yes.
interim relief.
Either on Monday or Tuesday.
Monday, Lordship, Tuesday have some difficulties.
Okay. What is your name?
Mika, Lordship. Mika.
Mika. Hi. Which is the Mika H.I., Learned Counsel for the petitioner. Also Mr. Imti Imsong, Learned Additional Advocate General, appearing for the state respondents. It is submitted at bar that this case is ready for hearing and may be taken up for final hearing on 18th of August. Considering the submission made by Learned Counsel for the parties, this case is admitted for hearing. Let this case be listed for final hearing on 18th August.
Admission hearing, Lordship.
Not admission hearing. We are admitting it. It will come in hearing column. Today it was fixed for admission hearing. So we have admitted it for hearing. It will come for hearing, final hearing.
Much obliged, Lordship.
For hearing, item numbers 24 and 25.
Witness, Your Lordship.
Question. Where is the cause list? That portion. Yes.
Lordship, here the petitioner is seeking for release of his release order and also to pay his pension benefits during the pendency of the criminal trial, Lordship. So, Lordship, here the brief fact is that, Lordship, while the petitioner was serving as a South Treasury Officer under Zumnabode District, Lordship, he was arrested in connection with one case that is which is registered at GR 80 of 16 under section, Lordship, 421, 420.
We are taking up
Lordship.
item number 24.
It's a 24, Lordship.
Yes.
These are both the item 24 and 25 are analogous arising out of same FIR, Lordship. From the same case, both the petitioner are the accused person in the.
But petitioners are different.
Yes, Lordship.
Okay, submissions will be same.
Yes, Lordship, the slight difference is that here in item number 24, the petitioner is yet to receive his even his release order. They have not issued. In fact, we came to know only when they filed their affidavit in opposition. And in item number 25, the petitioner sought for voluntary retirement on 2021. He has received his release order. However, his pension has been withheld. So we have also impugned that release order in the item 25, Lordship.
So let us take one by one.
Lordship.
One by one.
Lordship.
24.
Lordship. So in item 24, Lordship,
Yes,
so he was arrested
WPC 9 of
9 of 25.
20.
He was arrested in connection with a GR80 of 16, Lordship. And in fact, Lordship, here the petitioner, while Lordship, the FIR is at page 13, that is annexure B. May I read, Lordship?
Yes,
To the Director General of Police, Nagaland, Kohima. So kindly find enclosed with the 4 separate FIRs, which brings out 4 different methods of fraudulent withdrawal of pensions by criminals in Nagaland. Currently, it appears that one of the treasury, that is Sinoboto treasury, may be involved. However, the involvement of our treasuries cannot be ruled. Other treasuries cannot be ruled out. It is requested that the FIR may be registered at a PS, which has the jurisdiction over the entire state of Nagaland, so that the case can be closely supervised and monitored. It will be noted that the total fraudulent withdrawal may be runs into crores of rupees, Lordship. So that was the FIR filed by the Accountant General, Lordship, in the GR case, Lordship. So during this pendency, Lordship, here I have also annexed the charge sheet as annexure C, Lordship. And the petitioners here are charged under section 421 20B 409 468 471 IPC, Lordship. So even now the trial is pending before the learned court below, Lordship. And Lordship, during this, it was in 2016, Lordship, and during this time, Lordship, the petitioner here was also suspended for time being, Lordship. However, the petitioner approached this honorable court, and by filing the WPC before this honorable court, and the suspension order was also revoked. The suspension order is at page 76, Lordship, and as annexure D, Lordship. After the charge sheet, page 76 of my petition, Lordship. And after the suspension order, Lordship, the petitioner approached the consent department. However, it was not considered, so he approached this honorable court by filing WPC 67 of 2019, which is annexure F at page 78, Lordship. So the suspension of the petitioner was revoked by this, was quashed by this honorable court, Lordship, and he was reinstated into service. And till his retirement, Lordship, till at the time of retirement, he was serving as additional director, Lordship, under Treasury's, Lordship. So therefore, Lordship, after that, Lordship, on 18/12/2024, Lordship, the petitioner submitted the representation to issue for, he was retired on 2021, Lordship. However, his release order was not issued. So on 18th of December 2024, he submitted a representation before the concerned department to issue his release order and also to release his pension benefits, Lordship, during the pendency of the trial, Lordship. However, Lordship, the representation, it's at that annexure I, page 86, Lordship. The petitioner was retired on 1st June 2020, Lordship. And he waited patiently, Lordship. In fact, but he approached the consent department verbally. However, no action was taken on their part. So he filed this representation on 2024 only, Lordship. However, again, even after this representation, Lordship, there was no coming from the department. There was no coming from the department. So the present petitioner has filed this petition, Lordship, seeking for the release of his release order and also payment of his pension benefits, Lordship, during the pendency of this trial. Lordship, when it comes to the trial process, Lordship, the trial, there is around 41 witnesses, and only till date, only 3 of the witnesses have been examined, and other 39 are yet to be examined, Lordship.
what stand the state is taking for not.
State is saying that during the pendency of the criminal trial, the pension benefit cannot be granted closure. That is their contention. And in fact, in their opposition, they have stated that they have given the release order as well as the provisional pensions, Lordship. However, if in fact, if at all, Lordship, it is to be considered, Lordship, if they had released the provisional fund, provisional pension, we would not have filed this instant petition. However, we came to know only in the affidavit of opposition that they have annexed his release order as well as the statement that they have released the provisional pension of the petitioner, but that is not in our knowledge, Lordship. So
You are not getting provisional pension.
no, Lordship. In fact, he's yet to receive his release order also. Only we came to know through the affidavit in opposition that they have annexed it in their opposition. In fact, this petition is filed for release of his release order, to issue the release order as well as the pension benefits. If at all we had received the provisional pension, we would not have filed this instant petition, Lordship.
Okay, anything else?
And less, Lordship. In fact, the similarly situated person, there is also another ground that, Lordship, there is a similarly situated person who is also arrested in this connection. She is receiving her pension benefits and she is enjoying her regular pensions. But in our case, the petitioner was not considered, stating that there is a criminal trial going on.
In a separate case or in this
No,
case?
it's this same case, Lordship. She is also one of the accused, Lordship.
Where is that?
The accused, Lordship, the similar situated, the pension papers that I have annexed as annexed.
You have made a statement in your petition.
Lordship.
Where is that statement?
Lordship.
That who accused is getting pension?
That is at page 7, Lordship, of my petition, Lordship. That is para 8, if I may read, Lordship.
Yes.
This honorable court may kindly take note that a similarly situated person who is arrested in connection with the same criminal case is enjoying the pension right after her retirement, Lordship. And I have also annexed the pension, relevant page of the pension. Para 8 and 9, Lordship. That
What is the name of that
Lordship, apologies.
name of that person who is getting pension in spite of?
Choveli. She's accused number B4, that is at page 31, serial number. Lordship.
Yes.
Page 31, that is B4, accused number B4, Lordship.
Yes, Mr. Santam. Anything else?
Yes, Lordship. In fact, Lordship, the law is settled with regard to this that when there is no statutory law, Lordship, the pension benefits cannot be withheld during on the ground that the criminal trial is pending, Lordship. Lordship, I have some citations, if I may, Lordship. Two 2013-12 SCC, Lordship.
Yes. Which para?
Lordship, I'm relying on page para 10 onwards, Lordship. If I may read, Lordship.
Yes.
The present case is admittedly governed by the Bihar pension rules as applicable to the state of Jharkhand. Rule 43B of the state pension rules confers power on the state government to withhold or withdraw a pension or part thereof under certain circumstances. Under this rule, 43B read as under 43B. The state government further reserved to themselves the right to withhold or withdrawing a pension or any part of it, whether permanently or for a specific period, and the right of ordering the recovery from the pension of the whole or a part of any pecuniary loss costs to the government if the pensioner is found to be in the departmental or judicial proceedings to have been guilty of grave misconduct or to have caused pecuniary loss to the government by misconduct or negligence during his service, including the service rendered on re-employment after retirement. From the reading of the Lordship, I may also take to para 13 Lordship, since they are all reproduced Lordship. Para 13. A reading of Rule 43B makes it abundantly clear that even after the conclusion of the departmental inquiry, it is permissible for the government to withhold pension, etc., only when a finding is recorded, either in the departmental inquiry or judicial proceedings, that the employee had committed a grave misconduct in the discharge of his duty while in his office. There is no provision in the rules for withholding of the pension gratuity when the such departmental proceeding or judicial proceedings are still pending, Lordship.
Okay.
So Lordship, here in this judgment,
This
and
case,
also para
whether any departmental proceeding was drawn up.
Lordship, Lordship, there was a in his case, Lordship, yes, but in item of 25, there was no departmental proceedings, Lordship. Here there was, but it was also quashed by this honorable court, Lordship.
Okay.
And para 16 also, Lordship. Article 300A, Lordship. If I may read, Lordship.
Yes.
Para 16, the fact remains that there is an imprimatur to the legal principle that the right to receive pension is recognized as a right in property. Article 300A of the Constitution of India read as under 300, a person not to be deprived of the property saved by the authority of the law. No person shall be deprived of his property saved by the authority of law. Once we proceed on the premise, the answer to the question posed by us in the beginning of this judgment becomes too obvious. A person cannot be deprived of this pension without the authority of law, which is the constitutional mandate enshrined in the Article 300A of the Constitution. It follows that the attempt of the appellant to take away the part of the pension or gratuity or even the leave encashment without any statutory provision under the umbrella of the administrative instructions cannot be contained, Lordship. And 17, Lordship. It is hardly needs to be emphasized that the executive instructions are not having a statutory character and therefore cannot be termed as law within the meaning of the aforesaid Article 300A. On the basis of such a circular which is not having a force of law, the appellant cannot withhold even a part of the pension or gratuity. As noticed above, so far as the statutory rules are concerned, there is no provision for withholding the pension or gratuity in the given situation. Had there been any such provision in these rules, the position would have been different, Lordship. So in this case also, Lordship, there is no statutory rules with regard to the pension, Lordship. And in fact, also in 2000, Lordship, another citation. The same has been upheld in this, has also been relied in this judgment, that is 2024 SCC, Lordship, 346 page. Lordship, in this judgment, also the Honorable Apex Court has relied on the same judgment that I have relied on now, Lordship.
Yes.
So, Lordship,
Okay.
instead of repeating, Lordship,
So when there is no statutory provision,
yes, no, Lordship.
the pension cannot be withheld.
Lordship, that is the law, Lordship.
Okay.
And Lordship, allow me to place one SEC on it, that is 2016 SEC online, Bombay 1112, Lordship. Here, Lordship, I'm relying on para 3, 7, and 9, Lordship. Lordship, here they have also relied on the 2013 Apex Court judgments, and here also they have released, since there was no statutory law, Lordship, they have released the pension of the additional under Article Article 300A, Lordship. It's a right to pension, just Lordship. And also, Lordship, allow me to place another lines citation, which is 2021 SEC on 2021 2 GLT 587, Lordship. Lordship, here I'm relying on para 20, Lordship. Here it is also held as a pension as a matter of right, Lordship. And it is protected under Article 300A of the Constitution of India, Lordship.
Para?
Para 3T20, Lordship. That's all.
Yes, Mr. Santa.
Please, my lord. In both the cases, the issue involved the same. They were alleged to have involved in the fraudulent trouble sometime back in 2016. Accordingly, the State Crime Police Station had filed FIR, which was registered as PR 80 of 2016. And accordingly, both the petitioners were placed under suspension, but later on, their cases were considered for reinstatement. However, in WBC 9/2025, he retired as senior treasury officer with effect from 1/6/2020. However, the departmental inquiry is still pending. That was how his pensionary benefit could not be considered till date. And the prosecution witnesses as
But
of date,
you
it is
have,
yet to be completed.
you have to give provisional pension.
No.
Even if he is not found guilty, either in criminal case or in the departmental proceeding.
Yes, ma'am.
During pendency of the departmental proceeding,
My lord.
even if he had been in service, he would have got subsistence allowance.
My lord.
So some provisional, have you given any provisional pension? Oh,
I have stated in my report and following.
what?
If I may be allowed to read my
Yes, please.
Para 4, running page 2. That with regard to the statement made in para 2 and 3 of the requisition is admitted to the extent borne out of record. However, the deponent begged to state that while the petitioner was serving as senior treasury officer in the Bodo Treasury's office, he was arrested in connection with FIR case number 1 of 2016, registered as GR case number 80/216 on the allegation for his involvement in the fraudulent withdrawal of pension, annexure P and C of the writ petition. Therefore, he was subsequently suspended by an order dated 19 July 2016 in exercise of the powers conferred by sub-rule bracket 1 of Rule 6 of the Nagaland Services Discipline and Appeal Rules 1967, Annexure T of the writ petition. It is pertinent to state herein that the petitioner, by a letter dated 27/10/2017, had written to the Additional Chief Secretary and Finance Commissioner, Nagaland, Kohima, requesting for revocation of impugned suspension order dated 19 July 2016, and thereafter to reinstate in service with all subsistence allowance and consequential benefits. However, during the pendency of the petitioner's representation before the state respondents, the petitioner approached the Honorable Court by filing a writ petition which is numbered as WBC 67/2019, wherein the Honorable Court by a judgment and order overruled dated 4/7/2019 dispose of the matter, directing the respondents to reinstate the petitioner forthwith. Accordingly, by an order dated 7/8/2019, the petitioner was reinstated from service and was posted in the Directorate of Treasuries and Accounts till his retirement from service. It is also to state herein that by a notification dated 27/7/2021, the petitioner was released from service after attaining the age of superannuation, that is 60 years in terms of Section 3 Clause 1 and Section 3 Clause 2 of the Nagaland Retirement from Public Employment Second Amendment Act 2009. The said notification was issued in consonant and approval from the Principal Secretary, Personal and Administrative Reforms Department, O&M branch. And while issuance of the said notification, certain condition was laid down for the facts that since the case is pending against the petitioner,
in the State Crime Police Station case number 1 of 2016 GR 80/2016, which are as follows. Bracket remand number 1. As per Rule 9, Clause 4 of the Central Civil Services Pension Rule 1972, a provisional pension as provided in Rule 69 shall be sanctioned. Remand number 2. Further, as per Rule 69, bracket 1, bracket C of the Central Civil Services Pension Rule 1972, no gratuity will be admissible to the official concerned until the conclusion of the disciplinary/legal proceedings and issue of final orders thereof. Remand number 3. Furthermore, as per Rule 69, Clause 2 of the Central Civil Service Pension Rule 1972, the payment of provisional pension will be adjusted against the final retirement benefits sanctioned to the official concerned upon conclusion of the disciplinary/legal proceeding. No recovery, however, will be made in the event the pension finally sanctioned is less than the provision pension, or the pension is reduced, or the pension withheld either permanently or for a specific period. It is also to mention herein that the state government has adopted the CCS Pension Rule 1972 for the state government employees, and therefore, by invoking the rules under Central Services Pension Rule 1972, the petitioner was released from service. Therefore, no illegality, arbitrary or discriminatory action has been meted by the state respondents in issuance of the state notification, Annexure A, B, and C respectively. And if I may be allowed to read verify also my fault.
Yes.
That with regard to the statements made in Para 4 and 5 of the writ petition is admitted to the extent born of records. The deponents, however, begs to state that the petitioner approached the Honorable High Court by filing a writ petition which is numbered as WPC number 67/2019 for quashing and setting aside the suspension order dated 19/7/2016 and extension order dated 13/2/2018, and which was disposed of by a judgment and order dated 4/7/2019, directing the state respondents to reinstate the petitioner forthwith, Annexure F of the writ petition. Thereafter, the petitioner was reinstated into service by an order dated 7/8/2019, Annexure H of the writ petition. However, as stated in the preceding paragraphs, that while release order was issued by a notification dated 27 July 2021, as per the applicable provisions of the CCS Pension Rules 1972, a provisional pension benefits was sanctioned at the time of issuance of the release order, and moreover, gratuity was withheld as per the CCS rules for the fact that the prosecution sanction was accorded to the petitioner and no separate departmental inquiry was initiated. In addition to that, the departmental inquiry was initiated against the petitioner as the matter was already registered under the State Crime Police Station, case number 1/2016, GR number 80/2016, and the prosecution sanction was already also accorded to the petitioner. Para 6. May I read my note?
Yes, now there is no departmental proceeding pending against him.
No. Only the
Criminal prosecution.
yes, ma'am.
Then whether this CCS rules which you are referring to
Yes, ma'am.
is applicable in such cases.
Yes, ma'am.
It is-
Since we have adopted,
No,
the
no.
state government has adopted.
Is it provided there in that in case of pendency of a criminal case? The
Chip, there states stating that the pensions are made under the CS rule, Lordship. And in fact, in the section 67, Lordship, yes, we agree that there is a section rule 69, Lordship.
yes, Rule 69.
Lordship, there's a CCS.
Now let Mr. Sanktam,
Yes, my lord.
this Rule 69 is applicable. Whether Rule 69 is applicable even if there is a pending criminal case.
Yes, ma'am.
Yes, very. Yes, Miss Mika, you may read.
Lordship, in the Rule 69, clause C, Lordship,
Yes. 69(1)(c).
yes, Lordship. Clause C is, may I read, Lordship?
Yes.
No gratuity shall be paid to the government servant until the conclusion of the departmental or judicial proceeding and issue of the
Judicial
final.
proceeding. Okay.
Yes, Lordship. Lordship, that I agree, Lordship. However, they are stating in the position that they have also annexed the letter, Lordship. There, as per this letter, Lordship, which they have annexed is Annexure A. This is the letter to the AG, Lordship, stating that they are that the CS rules are applicable in the state of Nagaland, Lordship. And on that ground, basing on this letter, they are stating that the CS rule is applicable in the state of Nagaland, Lordship. However, in the apex court judgment is very clear that the mere that the mere executive instruction does not have the statutory character, Lordship. So in my humble submission, Lordship, that since there is no statutory rule, so I pray that the pension may be released on that ground, Lordship.
Yes. Mr. Sanktam. Yes, Mr. Sanktam.
My lord,
What else is your submission?
since for the three petitioners falls under the same category on the allegation of the fraudulent trouble before the state exchequer, they were placed under suspension.
Now whether they are getting provisional
No,
pension.
ma'am.
Only a decision was taken.
Yes, ma'am.
That they may get provisional
Only
pension.
when the prosecution witnesses examinations are completed and found not guilty.
But as per the rules which you have cited.
Yes, ma'am.
They're entitled to get at least provisional pension.
I leave it to your lordship.
Okay.
Most Lordship, it's in the subpara of the Rule 69 and subclause 2 of the Rule 69 that at least the provisional pension should be paid to the petitioners, Lordship, to the inquiry, Lordship.
Okay. You wait till next week. I'll deliver the judgment in the next week. Heard Miss Mika H.I., learned counsel for the petitioner. In both the cases, separate orders. Item number 23 and 24. No, 24 and 25.
24 too.
Yeah. Also had Mr.
L.T. Sanktam.
L.T. Sanktam, learned additional advocate general.
Along with
along with Mr. V. Zimumi, learned senior government counsel.
Permanently.
Learned senior government advocate.
No, he's a government.
Oh, sorry, learned government advocate. Appearing for the respondent side, state respondents. Hearing concluded, judgment reserved.
Much obliged, Lordship.